that we were still working through in terms of what's going to be offered. Mr. McDermott, had you had a chance to get through those materials?
I have, and I emailed Mr. Fawcett last night.
Okay, that we were still agreement on what's going to be offered in terms of what's going to be offered. Mr. McDermott, had you had a chance to get through those materials?
I have, and I emailed Mr. Fawcett last night.
Okay, that we were still agreement on what's going to be offered in terms of what's going to be.
I'm going to bring down this audio real quick, guys. Hey, I'm just going to live stream this. I've never really done trial coverage before, and this is my work day where I'm actually working as well. So this is going to be going on in the background for me. But wanted to let you know that I'm going to give it a go. Live streaming trials. This one seems very interesting to me. The fact that this is a 25-year-old cold case, that the defendant who is on trial now, I mean, what am I? Oh, give me just a second. I'm incepting myself there. So I'm just going to bring up the audio. We'll listen along together.
Only 2 photographs of her extremities
While I work.
that were located in the woods on that June date. Obviously, there could be several of those photographs, but there are only 2. The autopsy photographs, we have eliminated several, and the intent of the autopsy photographs is to show some of the tool marks. But we anticipate testimony from our anthropologists as well as our medical examiner to say that they observed what they believe some type of mechanical device, man action. We have eliminated used to separate, and the intent of the autopsy photographs is to show some femur bones from the torso. And so all that's relevant evidence, and the markings on that show the jury the marks that will be testified to, as well as corroboration of testimony. And I would submit to the court Davis versus the state. That is a Supreme Court case, 306 Georgia 140, 2019 case, specifically deals with defendant's objections as to the gruesomeness or objectivity, prejudicial effect of crime scene photos and homicide cases.
Yeah, and I mean, and let me save y'all some trouble. I am not of the opinion that just because things are gruesome that they are somehow prejudicial. If they're relevant, then the court will conduct an analysis under the appropriate rule of whether it's overly prejudicial, as is required. I think what I was hoping for is more to avoid accumulation, right? And so that what you're presenting is the evidence that's necessary and relevant to your case, and not, let me show you 9 pictures of the same gross thing that we all really don't want to look at when maybe 1 or 2 would suffice. That's really all I'm trying to accomplish here. And if you're going to show 9, I want to make sure there's some particular reason that that's necessary, and that I've conducted the analysis I need to ensure that it's not overly prejudicial, if that's what you're doing.
Well, if I can split these up, and I'm
Sure.
going to start with the autopsy photographs.
Okay.
If I'm looking at the autopsy photographs, the intent was to show each different section of the body that was discovered, as well as the tool marks that would be testified to.
Okay.
I do not believe there are any duplicative photographs of any one particular part of the body that was located. I don't believe there are any duplicative photographs of any of the tool marks as it relates to the images I intend to show from the autopsy photographs. As to the crime scene, obviously there are going to be photographs of what the crime scene looked like without the body there, because the body was, being transported, the remains. But it's important for the jury to have a context of where the location of the skull was located. There will be some testimony that they believe that there were dogs that were carrying the skull, or a bag they believe the skull was in, from the wooded area where the extremities were located to the street where the skull was found. There's going to be testimony that same dog had to be shooed away. And I think that as far as where the skull was found, where the sewer is, and the proximity of that to the job, I think is particularly relevant. And I think specifically as it relates to that Davis case, specifically crime scene photographs that are indicative of the location of where items, relevant items are pertinent, and although they may be prejudicial, I hope everything that I present is, that prejudicial effect is not outweighed. I think that this evidence is relevant, and I think it is necessary for the jury to see some of the photographs.
So you guys will forgive me if I'm listening along
I don't
while
have any
I'm
issues taking
working,
direction
okay?
from the court. Your fact finders or you independently feel as though
All right.
a certain portion of the photographs don't need to be played, that's fine. But what I got from the defense, I think, was limited in what they were willing to agree to. I didn't feel like that would have been representative of the case.
Okay, thank you, Mr. Fawcett. So, Mr. McDermott, let me ask a couple of questions as you begin your argument. So, I'm assuming for your record, you want to state your objection to all of them. Is that fair?
No.
No. Okay, well then, because really what I'm trying to get down to is if we assume that some universe of those photographs are going to come in, then what I'm trying to get to is what are the particular aspects, which particular photographs do you object to and why?
Well, I sent him the list last night. It was my understanding he was going to submit all that to you and
Okay.
go through them one by one. But it really what he described is actually what my point was. I'm not objecting to showing a head in the road as it was found. I mean, that's obviously relevant and important to the crime scene. As far as the discovery of the limb,
Head in a road. Holy cow.
there are only two pictures of that: one limb and one black bag. Well, I take that back. There are a couple of other black bags. I don't object to those. When we get to the autopsy photos, I understand we need to show tool marks because they're going to testify this was a saw, and we'll have a discussion about that. But do we need to see this is the left foot? No tool marks involved. Nothing about the crime scene. Nothing about cause of death. Nothing necessary to explain anything the medical examiner did.
So,
And then now the right foot. Let's look at the right elbow. Let's look at the
right, no, I understand that, Mr. McDermott, but I mean, setting aside that we're talking about body parts instead of one entire body, I mean, it is fairly standard to show for identification purposes, this is the body that was delivered to us, and after we cleaned it up, the condition that it was in. And usually the arguments I'm having are, but please don't show where you took off the front of their face to inspect their brain. And so I guess if that's the typical way that it's presented, then why would, here's the left foot, here's the right foot, here's the right arm, here's the left arm, here's the skull, at least those minimal baseline photographs, why wouldn't they be admissible? Why would they be overly prejudicial or not relevant?
I think the repetition of it, but in addition to that, we have multiple pictures of bones after the flesh was, as we understand it, steamed and cooked off of it. That is not necessary for them to determine anything.
Steamed and
Tool
cooked
marks
off
are
of it?
visible without that. Why do we need pictures of the bones laid out
Okay.
in an array?
Yeah,
So if
this
we could
case
just
is gonna be
limit it
interesting.
to what is absolutely necessary to get it across,
Okay.
I think that would be helpful.
So to that end, forgive me, I'm going to let you continue making your record, but to that end, I think what needs to happen then is, Mr. Fawcett, if you have a list that was provided to you from Mr. McDermott, if you can just email that to me so that I can take this flash drive. Are the exhibits identified by exhibit number on this flash drive, Mr. Fawcett?
Yes, the exhibit numbers are listed on the exhibit.
Okay, so I should be able, what my intention is to go through and look at the ones where Mr. McDermott has asserted an objection, where the parties don't agree, and then just go through, and then I can go through them one by one and provide you with rulings on their admissibility.
And let me just add, as far as the flash drive goes, it's one PowerPoint file, and the numbers of the exhibits correspond to the numbers of the slides in PowerPoint.
Thank you. That's very helpful.
I just also want this put on the record that there's I don't know what to call this. This is a printed out list of photographs that was included in the original discovery. I have never been able to find out who created this document, and we have never been provided with these photographs. There are multiple photographs clearly describing the crime scene where the limbs were found. And by my just looking at it, probably about 36 photographs. And I think that would actually be more helpful than the autopsy photos. But I would just love to find out who compiled this list so I could cross-examine them. And I've
Okay.
been asking for that for several days now. Don't get an answer, so
Okay.
put that on the record.
Mr. Fawcett,
Yes.
you're gonna email me the list that you and Mr. McDermott have exchanged?
Yes, Judge, I
Okay.
just did that.
Okay.
You should get that, and well, so, I think when we first started at the arraignment for this case, I know the court referenced how old the case was and how sometimes there may be documents that
I'm just going to bring down sound just a little bit, but this case, like I've just been tuning in, just listening a little bit, and we've got body parts. We have got, it's 25-year-old cold case. We've got steamed and removed. This is going to be
police department had reviewed.
a crazy interesting case. Oh my goodness.
We did that again a month after the case was indicted, just to ensure that we were complying with the court's discovery request. I believe that was required for the end of that year, I think 2024. And shortly after that, we got requests from the defense. I offered for the defense to come to our office to view our discovery. I think after we had the motion to compel, I advised the court that I had offered them to do that. I made another offer to do that. And I made a third offer in writing, emailed to Mr. McDermott, I think maybe 3 weeks ago. Last week, Mr. McDermott emailed me and asked me what day would be a good day to come over and view our file. And my intent was to make the Atlanta Police Department lead detective's file available, Detective Shepard. My intent was to go back to the annex. I know how important this case is. Go back to the annex and look at it again. Part of doing as much due diligence as I could. I offered Mr. McDermott, I believe Tuesday and Wednesday of last week to come over and view it. When we talked, we discussed the discovery. We didn't discuss that date. I assumed he no longer was interested in that. But I've looked in every file that we've had. I've looked at the annex. I've looked at our digital files multiple times. And every document that we have in physical paper form and digital form has been turned over to the defense. I don't have any other documents.
Okay.
My complaint is not that I don't have enough documents or that these photos are missing. I can understand that that's the case. I just want to know who made this document and can I call them as a witness? And that's not unreasonable. They have access to Mary Beth Hoptel. They have access to T.R. Miller. They have access to all the investigators who worked on this back in the Calhoun days when this would have been created. And they can surely find out who created the list of photographs and their descriptions so that I can cross-examine them.
And Your Honor, I did inform counsel that there were 2 investigators that were working on this case. It was Mike Alsip, whose name is in the discovery, whose name is on several.
Hang on, let me back up for a minute. Do you know, is the issue that you don't know who created that document?
I don't know who created that document, but I can say that.
Right,
There were
okay.
2 investigators that could have created it.
Sure.
Mike Alsip, who was an investigator with the Fulton County Medical Examiner's Office, and investigator Tina Miller, who is on the witness list and going to be testifying, who was also an investigator. That's an investigative report, and there was one of those 2 investigators made that report.
Okay.
I mean, I guess I can wait till she's on the stand and roll the dice. And
Well,
ask-
have you had an opportunity? I mean, I assume those individuals were identified to you either specifically as people with information
Yesterday.
or on documents that were in the file in terms of reports that would have been provided through discovery of their involvement in the case.
I mean, they have been on the state's witness list. But
Okay.
as far as their involvement with these documents, I didn't know, and I learned that yesterday.
Okay.
I still have time to try to call them between now and then, although I think T.R. Miller's scheduled to testify today. So.
Okay. So here, I think that if the state has identified that they don't know who created that document, but that it could be either of 1 or 2 people, and those people are identified as witnesses, or through their role were identified in terms of their involvement in the case, that they've been identified sufficiently for purposes of discovery, and that to the extent that one of them is going to testify, I don't think it's unreasonable for you to ask to, inquire with them before they take the stand, hey, is this a document that you created?
Go ahead. Those names were mentioned to me yesterday. I was not told, we don't know who did this. You'll have to pick from these people and find out for yourself. I was not told that they didn't know. I was under the impression that they were still going to try to find out for me.
Well, I understood from Mr. Fawcett's answer that he did try to find out, and he hasn't been able to find an answer, that it's got to be one of these two people.
Then there was
But-
lots of communication yesterday.
Well, Your Honor, I think co-counsel has a suggestion. I'll reach out to the original detective, Calhoun. I'll forward these to him to see if he can assist. He may have the name of a crime scene detective would have created that document.
Okay,
I'll do that.
thank you. Anything else on the topic of photos for now, Mr. McDermott?
Not those photos.
I do love how they are able to just kind of work through problems.
Well, there were two sets of
It's
photos
actually
we were talking
pretty cool
about. One
system.
was the list of photos that has not been produced to you, that Mr. Fawcett says do not exist as far as he's aware, digitally or in paper. And then there was the second set, which are the ones on this flash drive that I'm going to look at and rule on. I have now received Mr. Fawcett's email regarding the ones they intend to offer that I need to actually look at in terms of your objections. Any other issues on photographs that we need to address?
I'll just say yes because Mr. Fawcett just gave me this morning a stack of new discovery. And, well, about half of this is stuff that's old discovery, and about half of it is new discovery that would have been nice to have even just a week ago. But these are cards and letters and photographs written between Norma Patton and allegedly Melissa. And, I mean, it's just dumped on us right before trial, so that's a discovery violation in my opinion. I've heard tale of these cards and letters for ages now.
I believe I heard you during pretrial argument say, where are those cards? Where are those letters, right? So,
Recently? Yeah.
on Monday during pretrial, when we were talking about statements
Well,
by.
it's nice to have an answer to my question. I agree with you. But it's still a discovery violation. That should have been turned over. If they existed, which they did, that should have been turned over a long time ago.
Okay, and we can talk about that when you're ready to talk about that, but those aren't photographs and we're not talking about that just now.
Well, there are photographs in there, so.
Okay. But I'm assuming not the graphic ones involved in
Well, I was
Ms.
trying to be
Wolfenbarger's
clear
death.
that it doesn't pertain to the foreground. I'm sorry, that's my fault, and I'm being a bad boy. I just admit that's my fault. You said any other photograph.
Sure.
I made that jump, so.
That's fine. What about the audio of Mr. Wolfenbarger's statement? Have we agreed on the portions that will be played for the jury?
I think we have an agreement to maybe 80 or 90% of it. There's a portion we've agreed to start at 15 seconds earlier. I'm agreeable to redact and a part in the middle that counsel has requested. There's a part towards the end where the lead detective is asking a question and he is indicating his theory about where the skull was possibly washed out of because it was rain the previous day.
The detective is saying that?
The detective is saying
Okay.
that to Mr. Waffenbarger, and Mr. Waffenbarger responds the way he does. But I think there's other evidence that the skull was likely dragged out of the wooded area. So counsel is requested to redact it. I don't think it needs to be redacted. I think of scenarios where officers ask and make all types of statements to defendants to elicit a response or to see if there is a response. I don't view that as any different. If Detective Shepard and Detective Layton are asking Mr. Waffenbarger a question, even if they are misrepresenting the crime scene, courts have said that it's not to say that that was the intent or what was happening. Courts have even approved officers lying to defendants or suspects. So I don't think that this is a situation where that was taking place, but certainly, even if the crime scene was not in line with other theories, a question about that to the defendant shouldn't be excludable just because it may not line up with other theories, it still elicits a response from the defendant that I think would be relevant for the jury to consider.
Mr. McDermott?
Yeah, my concern with that particular statement is not that it's just some random theory of the detective. He's not telling a lie. There are some speculation in the early police reports that there may have been a weather event that washed the head out into the road. It clearly was picked up and used by later detectives.
Oh my goodness.
For example, Detective Shepard has used that theory when speaking not to Mr. Wolfenbarger, but to
There was
other
a weather
witnesses
event that
as
washed the
explanations for
head
how the
out
head
of.
may have gotten
Oh my
there.
goodness.
So clearly, this is something that was important to the investigation, and they weren't treating it as a lie to try to get a reaction. And particularly Sergeant Layton's statement in that video is correcting or trying to help Christopher with his understanding at the time, and he says, "It is my understanding that there was a strong flood of water that washed this out into the street." So that's how it got there. And he says it in such a way that I'm afraid the jury will take that as evidence that something happened. He says it in such a confident way that it's his understanding I think it will confuse the jury.
Is that individual going to testify?
There are two individuals there. The Detective Layton is not scheduled to testify, but Detective Shepard was there. He's on the video. He introduces himself to Mr. Wolfenbarger and is present throughout the entirety of the interview.
Okay.
So that was my second point I was going to make, is that Sergeant Layton is not on the witness list, and he's not going to be available to testify on that point. So I just don't want the jury to get confused about that. So at the very least, if we don't redact that, if the court would provide some limiting instruction on that point.
I'm not sure what the limiting instruction would be. It seems the reason I asked about whether the witness or some witness could testify about the circumstances of that statement, certainly with knowledge of the investigation, is that seems like a topic for cross-examination.
Okay, fair.
In terms of whether that was accurate or whether you have information indicating that it was accurate. So I am going to the extent there was an objection as to that particular question, I haven't heard anything that would require it to be removed currently. The objection, as I said, is more subject to a subject for cross-examination of a witness that would testify about those conversations. Given that ruling, if we then have sort of a universe of agreed upon audio, if y'all can please reduce that to some secondary exhibit, which will be what's played for the jury, with only those items that either the parties have agreed or I have ruled will be admissible, that can play as continuously. And then, as I said, when we're ready to play that, I will instruct the jury that there may be, jumps in the video. There may be things, it may appear to them that things have been removed, or that it's been edited and that's been done at my direction, and that they're not to draw any conclusions from the fact that things have been removed from the video or audio, and they're not to speculate about what might have been removed when it's time for that to be played. What exhibit is that going to be, Mr. Fawcett?
That is going to be, and I do have a list for the court. I just wanted to see what the ruling was. Let's see. That is going to be Exhibit 30.
And so y'all are going to have an Exhibit 30A, which is just the relevant portions that we've agreed on. Is that right?
You can do that, yes, Judge.
Okay, thank you. As I said, what I'm just trying to avoid I'm going to start it and stop it, and then I'm going to start it and stop it, and we just have something that we can agree to play. It is more efficient. Okay, couple of other issues. So I have spent a good bit of time with the forfeiture by wrongdoing issue that was raised by the defense. Specifically, I've already ruled that non-testimonial statements that Ms. Wolfenbarger made to family and friends, that those family and friends can testify about those statements. There is the secondary issue, though, was that there are as I understand it, there are statements made by Melissa Wolfenbarger in court records in service of a TPO application, and to police officers as part of, I think, an investigation into that initial event that occurred.
I just realized I was on
Brookline
mute.
Avenue, if I'm remembering correctly. And that those are, I think everybody agrees, those are testimonial in nature. And
Marie, this is in the Atlanta, Georgia area.
confrontation clause. And the state's argument is that those statements, that Mr. Wolfenbarger has waived his confrontation rights as to those statements because of
Yes.
his wrongdoing in causing the absence of Ms. Wolfenbarger.
And sorry about that.
So as I understand that provision, it isn't just that the defendant, that the state can demonstrate by a preponderance of the evidence for purposes of this, the application of this exception, that the state can demonstrate by a preponderance of the evidence that Mr. Wolfenbarger may have caused Ms. Wolfenbarger's absence. It's that they have to demonstrate that second piece, which is that the purpose of the causing the absence was to prevent the testimony. I don't have it up right now, but what I located, I looked at a bunch of case law. The most recent one I saw was from Judge Dillard in the Britton case. And I found that to be particularly educational because what Judge Dillard does is spends about a paragraph explaining the circumstances of that witness going missing. And that was satisfactory to the Court of Appeals that the defendant may in fact have caused the person's absence. But then importantly, they add a sentence that says there was evidence in the case that the defendant had made a statement to, I think, a cellmate that the defendant was not worried about that witness testifying. And I think that's the concern I have here is that we have.
I like hearings like this where everybody's colleagues and they're working together to get the trial going. I like this stuff.
Absence. What I'm not sure I have is evidence other than potentially an inference from the circumstances, but that inference has to be reasonable to satisfy the preponderance standard, and I'm not sure I have enough. And so based on what I have heard so far from the state, I don't believe that they've satisfied the burden to demonstrate the forfeiture by wrongdoing standard. And so, as I said, to be clear, I believe they've satisfied and demonstrated by a preponderance of the evidence that Mr. Wolfenbarger may have caused Ms. Wolfenbarger's absence. But I've not heard evidence that either establishes or from which the court could draw a reasonable inference that the purpose of that absence, the purpose of his alleged action in causing her absence was to keep her from testifying against him in the domestic violence or TPO matter that was pending at the time. And so that's going to be my ruling. Mr. Fawcett, do you want to make a record regarding that issue, sir?
Not necessarily, Judge. I accept the court's ruling. I do have several exhibits that are certified that are representative of that criminal case, such as the petition. There's a Rule 9 size setting the court date down. There's an order restricting contact, and then there's a request for dismissal by Ms. Wolfenbarger. I would still believe all those documents are relevant. What I would still be asking the court to allow the state to tender those into evidence. I would not be publishing the portions of those documents where Ms. Wolfenbarger's laying out the testimonial statements.
Right. Well, I'll hear from Mr. McDermott, but on its face, I agree with you that the existence of that case is not a matter, it is subject to a different hearsay exception that would allow potentially its admission, and it would seem to be relevant. But we were talking specifically about the statements of Ms. Wolfenbarger to officers and or in those documents. Mr. McDermott, your thoughts on that issue, sir?
Well, we would like to see his proposed redactions.
Sure.
What he wants to do and be able to talk about that perhaps over lunch.
Mm-hmm.
And go from that point.
Okay. I mean, I'm not ruling that they are admissible because no one's asked me specifically, but as I said, at first blush, I tend to agree with you that those would be relevant and potentially admissible under different hearsay exceptions. Anything?
The law is so complex, man.
Anything else that, there was a motion in limine that was filed by the state, I think last night. And I need some help with it because I wasn't quite sure I understood what we're trying to limit. obviously, we've understood for some time now that the fact that Carl Patton is a convicted murderer, right, was going to come into evidence in some manner, right, that was going to be an issue in this trial. So I'm not exactly sure what you're asking me to allow or to forbid. Can you help me, Mr. Fawcett?
And so I guess as laid out in the motion, this is, as of the past week or so, I think it kind of gives me some insight into what possibly could be asked or attempted to elicit during the course of the trial. And as I've laid out, the only reason why Ms. Melissa Waffenbarger's father is relevant in this case is because his arrest really jumpstarts the identification of her. And I don't know when she would have been identified, but for the infamous arrest of her father and him saying, "Find my daughter." That's pretty much what we've heard repeatedly by the medical examiners, the lead detectives, and everyone involved. But to take that information and now to attempt to introduce letters from Carl Patton, to what I'm trying to avoid is a relitigation of the case involving the Flint River killer, because all the particulars of that case simply aren't going to be relevant for the determination of whether or not Christopher Waffenbarger murdered his wife. So it's one thing to say, well, he was arrested. It maybe is relevant what he was arrested for, maybe, but outside of that fact, and the fact that that arrest triggered the identification, that's what the detective, Bruce Jordan, was the notifier to the medical examiner's office of that missing woman, Melissa Waffenbarger. That triggered the retrieval of the dental records from William Brantman. And that was the comparison that made the identification. So outside of that, what
Hopefully that
parts of the
improved
case
the audio
would
here.
be admissible? I don't believe that the statements of Carl Patton will be admissible. I don't believe that the particulars of the case itself will be admissible. So I don't believe that the defense should be able to ask Norma Patton, well, tell me how many people did he kill? Tell me the circumstances of that. How is that relevant for whether or not Christopher Waffenbarger killed Melissa Waffenbarger? It just is not. And I think that in particular is something that confused the issues in this case and confused the jury.
Okay, Mr. McDermott?
We disagree, Your Honor. We think that the only point of relevance being that he helped them identify who she is just the tip of the iceberg. There's an entire developed body of case law which has been even more developed recently by the Supreme Court regarding evidence of third-party guilt. This is a classic whodunit case. The state has only circumstantial evidence that Christopher.
Just want to check that you guys can hear the audio okay.
We have
You know?
substantial evidence that there could have been other people who were involved in her death. And the Supreme Court has recently said the standard for third-party guilt is basically going to be 401, 402, 403. And they have telegraphed that in their most recent opinions, even though it's not the precedent, I'll grant you. They've telegraphed that. They've said the test is going to be, if this evidence makes it likely, tends to make it likely, using the I got it off my head, the rule for relevance, more or less likely that he's
not,
guilty,
right? Yeah.
then it's relevant. And then it's only a 403 test after that. Well, Carl Patton's murders, it's not just he killed 5 people.
Okay, I'm
back in
putting
the
it back.
70s and that was
It's
it.
the
It's
volume's
why
going to
he
be a
killed
little
people.
lower
It's his
than mine,
motives for killing
but
people. It's
it will
who
be
he
less
killed,
echoey.
his friends and family, the way he killed them, wrapping them up in bags and dumping them in the river. It's the fact that he drove miles and miles to try to hide bodies. It's the fact that Norma Patton, who's going to be testifying here today, was right there hands-on helping him for 2 of those murders. She helped him. And what I intend to ask her about is only what she testified to in court. It's a certified court record that she helped. She helped plan the murders. She helped watch. She was in her living room. They shot the people. They fell. She helped clean up the blood. She helped carry the bodies out.
So let me stop you for a second and set what I think are going to be 2 signposts here before we get more granular, right? One is the fact that Mr. Patton exists, that he is a convicted murderer, that he, I think, was briefly considered a suspect, although my understanding is obviously the state changed its mind and decided that it wasn't Mr. Patton. But all of those things are relevant, and I think that the state can't limit the relevance of Mr. Patton's existence and his history, right? Like how it's relevant to Melissa Wolfenbarger as a general proposition. Also, certainly, I fully expect that if Ms. Patton, Norma Patton, takes the stand, that there will be a thorough and sifting cross-examination about her involvement as a credibility matter, right? And as a convicted felon or whatever, charges she pled to. All of those things I think are absolutely going to probably come into evidence. As a general proposition. What I'm concerned about is that
Thanks,
part you were
JoJo.
just talking about in terms of satisfying 403 from a basic relevance perspective, and to avoid getting too far afield of the issues in the case is my general feel is I don't really want to get into relitigating the circumstances of the murders that Mr. Patton committed unless you can show me the specific reason that they would be relevant to this issue. And right now we're just having a general argument and you're just making a proffer, but that's what I haven't heard.
Well, I would reiterate the points that I just did. They're certainly relevant to how these bodies were disposed. They're relevant to who was killed and potentially why they were killed. There's evidence that Melissa knew about Carl Patton's murders, which is something he kept under tight
But
wraps.
again, that's the fact of the murders, you're talking about the
This is her
circumstances.
her
It's a
father.
motive for the murders. And it would be a motive
Is her
for this
father a
murder as
convicted
well.
murderer?
That's evidence of third-party guilt. It's relevant.
Mr. McDermott, I think we're talking past each other.
Okay, I'm sorry.
I'm not saying that you're right now,
Yeah.
as a baseline guidepost, general proposition here. I'm not saying that I expect the defense is not going to talk about the fact that Carl Patton is a convicted murderer. And I'm not saying that you're not going to cross-examine Ms. Patton about her involvement and that sort of thing. I'm also not saying that the fact that he's a convicted murderer might have some relevance to this case and whether whether Melissa had motive or whether that might have formed some motive for Mr. Patton to be this alternate theory of the crime murderer, right? That's not what I'm saying. What I'm saying is I understand Mr. Fawcett's argument to be, it sounds like you want to go in and let's have a little mini trial about the circumstances of each of those murders. And that's what I'm trying to figure out. Why would anything other than the fact that he committed murder, right? Even the numbers, even the names, but why would the individual circumstances of those offenses, other than potentially some leeway to cross-examine Ms. Patton, Norma Patton, why would that be relevant?
Well, can the court help me out here?
Mm-hmm.
When you say, oh, I lost my point, I'm sorry.
Sorry.
In the last thing you said, obviously we would agree that the fact that he committed murder is relevant. But you're saying what more than that is relevant? You're asking me what beyond that would be relevant in this case. And I think anything that okay, let me go back to the point. You're saying we don't want to relitigate this case. And you hear me trying to relitigate the Flint River.
Yes.
What part about me reciting the facts that are on court records in a guilty plea hearing, what part of that is relitigation? These are just
Guys, I'm looking
facts
this up.
about
Yes,
how those
the
murders
victim's
happened,
father
who
is a
motives were,
serial
who
killer.
they killed. Those are facts on record, testified to under oath. There's no litigation happening. But those are facts
Carl
on record
Patton
that are relevant to the facts that'll come out in this case.
Was arrested for the
and that is
1970s
directly
Flint
relevant to
River
third-party
murders.
Okay. So, Mr. Fawcett, as I understand the state's motion, it was
What?
an effort to limit the nature and scope of evidence that will come in about Mr. Patton. Is that a fair general characterization?
Absolutely, Judge, that's correct.
Okay. So,
And let me just say this, if I may.
Sure.
I sometimes can miss things, but I don't know that we've received the transcripts that are being referred to by counsel.
Well, that's a different issue. Well, and when and if that arises, because I can't deal with all of these issues in a vacuum in the abstract, right? Some of these are going to have to come up in the moment, and that's fine. What I'm trying to do, which I think is the purpose of motions in limine, is to give the party some general guidance about what's okay and what's not. And I think that Mr. Carl Patton's existence history and affect, the fact that he was even briefly a suspect, the fact that Ms. Patton was allegedly involved in his murders or in cleanup, whatever, right? Those things are fair game, and I think that that to the extent the defense, I think those things are going to be facially relevant and not overly prejudicial. What I am concerned about, though, is confusion of the issues and prejudice that might arise if we go too far into the granular details, absent a clear showing of specific relevance of those details into the details of the killings committed by Carl Patton. And so that's my general guidance to you, understanding that as we start asking questions and get into the back and forth of actual witness presentation, you may satisfy me that it's necessary for you to go into
The thing that I was just thinking about here, guys, is that Carl Patton is a convicted serial killer,
but right now, in a vacuum, absent a particular
and
showing
he might be the only serial killer in the history of ever that knows what it feels like to have a loved one murdered. Crazy.
Just showing that it's relevant for your purposes in this case.
This is
So,
crazy.
Just to be clear, what I've already mentioned about the motives, at least in 2 of those killings, to keep people silent who were going to talk about his murders. Is that 50,000 foot level, or is that down at granular level, or where are we talking about? Because a general motive for killing somebody seems to me would be directly relevant to this case.
So I think you're asking me to conduct a sort of
Okay.
quasi 404B analysis, right? In terms of, I understand Mr. Carl Patton doesn't have any 404B rights in this trial, but
But also, that's been specifically talked about in the case law.
I understand.
404 does not enter into the analysis at all.
I understand. I guess my point here is I've given you, I think, what are the general broad strokes. And so beyond that, I think you need to conduct your examinations of your witnesses in the way that you believe is necessary, and I will deal with individual objections as they arise.
I like this,
Again,
Judge.
My point is, Mr. Patton's crimes, that they happened, that he was convicted for them, that Ms. Patton was involved in them, I think those are all, we're all expecting those are going to be relevant and discussed in this trial. I'm just trying to avoid getting down into the nitty-gritty of it unless it's relevant and necessary for you. And if that's the showing that you're going to try and make, then I may agree with you. I'm just not going to do it right now.
Okay.
Okay? Anything else that we need to take up pre-trial?
Last thing, Your Honor. Good morning.
Good morning.
I know that there may be some witnesses that have criminal histories. I believe some may be older than 10 years. It is my understanding that we have not received any notice from the defense if they're going to try to impeach using convictions older than 10 years. And so I just wanted to bring that issue before the court, 'cause I don't know if they exist or not, or if they plan to, but there needed to be notice if that was going to happen. And so wanted to
The wheelchair
kind of
is
deal with
killing
that
me.
before a question comes out on the stand and we haven't addressed it, Your Honor.
Mr. McDermott?
Off the top of my head, I can only think of one that might be in that category. And in 1991, and it's not an impeachment issue. It's another third-party guilt. It's actually to explain one of the reasons Melissa ran away from home. And in 1991, her sister had a baby in their house. I don't know if it was unexpected. Certainly it could have been unexpected, but she did it in secret. She didn't want to keep the baby or something of that nature, and tried to secretly dispose of that baby in a clothes hamper in their house. And we have
What?
Court records from that conviction. I'll finish the story briefly. Melissa is the one who found that baby, and she didn't know what to do with it. She ends up telling people at school, and then the police come. Long story short, Tina ends up getting convicted for concealing the death of another in 1992. I don't even really need to talk about the conviction aspect of it. I just need to talk about the crime and what happened to Melissa. And, you know, it was shortly after that 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 was the final straw for her. She starts running away from home regularly. So I do want to talk about that incident. If it's going to be an issue with the conviction or whatever, I'm not bringing it in for impeachment purposes.
Okay. So two things. One, I agree generally with Mr. McDermott's characterization that everything all the circumstances that led up to whatever conviction occurred might be relevant with particular witnesses or whatever, and the fact of the
Hey, when they take a break, I will look for a brief on this.
although I agree with the state that if you wanted to talk about that conviction, then I think there are some notice obligations. That's number one. Number two, though, is setting aside the notice obligations from a substantive perspective. The purpose of the rule prohibiting convictions older than 10 years is because presumably they're stale. They're not particularly compelling or relevant to the veracity of a witness who's testifying now. But if we're talking about events that occurred more than 20 years ago, right, then the fact that they were convicted of something 22 years ago might be more relevant than it normally would if we're talking about a crime that happened last year and somebody wants to try and impeach or bring in evidence of a prior conviction from 10 or 15 years ago. And so that's my only concern, Ms.
And we
Hilton.
understand that, and I guess this particular incident, what I think the state is having an issue with is the relevancy of Ms. Tina Patton having a child and Melissa.
So forgive me, Ms. Hilton, for interrupting you. I'm not ruling that that information is admissible. What I'm saying is that Mr. McDermott is not, to my ear, indicating that he intends to offer evidence of a conviction of that witness, which means there would be no notice obligation, number one. And number two, the issue about the substance of what he wants to offer, that I'm going to have to deal with that when it comes up. I don't know what the relevance is yet because I don't know why he would offer it. He seems to think that he has some facial basis to make a showing of relevance at the appropriate time.
Thank you, Your Honor. I definitely understand the notice requirement if that's his understanding. My concern now, hearing what he may offer it for once the witness is on the stand, is that we can't unring the bell once he asks whatever question he asks in a moment for me to object. If he asks, did you kill your baby and leave the baby at home, and then I object, that question is already out and for. So if he's going to use, I want to deal with it maybe in a motion in limine that's not relevant. But I'm not fully understanding all of the facts that he would like to bring in, since I'm just hearing about it now.
Mr. McDermott, why is it that you believe, I assume that you plan to go into that when Tina Patton is on the stand?
I intend to mention it in opening, actually, Your Honor, because one of the key issues running through this trial is Norma Patton's claim that she had a loving relationship with Melissa. And we're going to put up lots of evidence that that was not the case. That Melissa wanted to come back home and Christopher wouldn't let her. That Melissa kept trying to leave Chris and come back home to them, and it's just simply not true. And we have tons of reasons why. And one of the reasons why that led to her initially starting to run away is the discovery of this baby. And that was the last straw.
This is
going to be a testament
crazy.
to the
I can't think of another word for it.
Relationship she had with the people in that home and her opinion of them. And that's all
Yeah,
relevant
Julia,
to why
that's correct.
she
That's
did
what
not
I
have the
understand.
relationship that Norma Patton is going to claim on
I
the
looked
stand
up an
that she did
article
have.
interviewing Mac McCollum. I believe
Hilton?
that's true.
Your Honor, because Ms. Wolfenbarger isn't here, some of this would be speculation on the part of anyone to say this is the reason why she left home. So we don't even have credible, I believe, evidence as to this is going to be the reason why she went home or one of the many reasons why she went home. So now we're on a fishing expedition to ask questions that are speculative in nature as well as not relevant in this particular instance as to whether or not Mr. Wolfenbarger killed or murdered his wife. I think we're now going to essentially try to muddy the waters in this trial to put in all of this extraneous evidence, and it's taking away from whether or not Mr. Wolfenbarger killed his wife. And so this particular evidence of a baby being killed
I'm just going to pause this for a second, make sure that I'm unmuted. Real quick, just the 411 on the case, okay? And I'm not going to be able to share this screen with you, but I'm just going to read it, okay? So Melissa Dawn Wolfenberger, maiden name Patton, daughter of Carl Patton, age 21, was last heard from during a phone call to her mother on Thanksgiving Day of 1998. She vanished sometime afterward, and her husband, Christopher Wolfenberger, never reported her missing. In April of 1999, a bleached, severed skull was found in a garbage bag in a wooded area of Atlanta. In June of 1999, additional dismembered remains, excluding the torso, were found in black trash bags nearby. These remains were located close to where Christopher had worked. The remains remained unidentified until 2003 when DNA testing triggered by the arrest of Melissa's father, Carl Patton, a convicted serial killer known as the Flint River Killer, allowed authorities to confirm they belonged to her. Carl Patton was quickly ruled out as a suspect in the murder. The case gained renewed attention in the 2020s, notably when investigator Mac McCollum featured it on her podcast Zone 7 in early 2023. A listener responded with a tip that eventually led investigators to revisit the case, re-interview witnesses, and re-examine evidence. This is why I freaking love the true crime community. It was Mac. It was freaking Mac. It's amazing. Okay. Although police have not disclosed the exact evidence or motive, they stated it appeared related to domestic violence, noted that re-interviewed witnesses and new examination of evidence led to the arrest. The trial, earlier in 2025, a motion by the defense to dismiss the case, citing 5th and 14th Amendment concerns over the delay in charging, was denied. Plea hearing was scheduled for May, and the case continued through the court process. So that's where we are.
Killed in a home or potentially being killed in a home, and this is the reason why she's running away. It's speculation. I don't know who's going to testify to that. So when you start asking those questions, now you are bringing in issues that are confusing the jury without any clear evidence to that, Your Honor. So that is our position as to why the details of this particular incident is not relevant, Your Honor, in this case. It'll be speculative and it's not relevant.
Okay. I agree with you. If the defense tries to argue or to get a witness to say, isn't that why Melissa ran away or whatever, that's argument, right? But if Mr. McDermott can establish facts that created what he's going to argue was a hostile home environment that would not lend itself either to indict the credibility of those witnesses or to demonstrate why Melissa wasn't there, I think that's fair game. But again, I would like to caution that there is a risk here of confusing the jury, of inflaming the jury with things that are extraneous. And we're all going to be very cautious about engaging in that endeavor.
Thank you, Your Honor.
Okay. Anything else?
Nothing, but I just emailed Ms. German for the Zoom link. I did intend on using PowerPoint going over.
Okay. Ms. Johnson, if you can hear me, or Ms. German, if you could make sure that the lawyers have the Zoom link for today so they can log in. Last thing, Mr. McDermott, anything else you need the court to address pretrial?
No, ma'am.
Okay.
Just in this hearing alone, this case just boggles the mind. We've got a serial killer father. We've got a discarded baby in a hamper. A woman who is a young woman runs away.
So the last thing that I needed to take up, I do have all of my jurors. I did want to let you know that juror number, no, not that one, the dialysis. #43, who y'all will recall is the gentleman that we that told us that he was on home dialysis. He has presented today. He is here But he has also sent to my office a letter from a physician at Dialysis Care Center asking for that individual to be excused because he has a diagnosis of end-stage renal disease. My understanding is, I think the numbers indicate that he is an alternate, but he is here. I think there was a discussion on the record when we were talking about whether or not to excuse that juror for hardship that I think I and the lawyers asked him any number of questions about whether he could make it work. And it seems like maybe he doesn't think he can, but he didn't say that clearly during the process of voir dire. What are our thoughts on what to do with that? Now, I feel like if he's here, I need to inquire, is he asking to be excused, right? Because this letter, since he didn't say that, number one. Number two is if it's a matter of accommodating him from a time perspective, right? I can say, hey, well, I'll guarantee you we'll be out of here every day at 5 o'clock or whatever I might need to do to enable him to conduct his home dialysis timely. What are your thoughts, gentlemen?
I would agree with that, yeah.
I agree.
Okay. With your permission, I'm going to have, rather than bring him out here to ask that question, I'm going to have my staff ask, are you aware we've received this letter? Because this letter was faxed directly to us from the healthcare provider.
I was not aware.
I'm sorry?
No, go ahead, Thompson.
And I'm going to have Ms. Sherman ask him, are you asking to be excused? So that I can then make that clear to y'all, and then y'all can make a decision about whether we wish to excuse him or not. Everybody good with that, Mr. Fossett?
Yes, as long as the defense is.
Mr. McDermott?
I'm good with that.
Okay. Mr. Dermott, come here, please.
I covered a murder trial once where on the second day of trial, just 2 jurors decided just not to show up. They didn't show up for the rest of the trial. And a bench warrant was issued for both of them. I don't know what happened to them because I don't know their names to look it up. But yeah, crazy the things that people do. I'm not saying this guy's doing that, but yeah, very interesting. Man, I've got the longest report ever running.
Anything else while I wait for that answer? Okay.
So if we excuse him, or are we considering getting another alternate? Or we haven't got to that stage yet?
Well, he is an alternate, so I mean, we would just proceed with only one alternate.
That was the question.
Yes, sir.
Proceed with one, or go ahead and try to find another one? That's y'all's decision. I'll do whichever you ask. Logistically, seating another alternate at this point and getting them here from whatever corner of the county they reside in might mean that we're starting opening statements at 1 or 2 o'clock instead of at 11. I'm told that he seems quite comfortable back there. That was one of the reasons I wanted to ask if we can accommodate you to make it easier. Are you asking to be excused, or did you just want us to be aware of this medical information? So I don't know that y'all can think about what your options might be if he says he wishes to be excused, but I don't know that we have to solve that problem just now because he might say he's fine. He'll take it day by day.
they're just waiting to hear back on that juror. Jess says Flint River killer typically wrapped his victims' bodies in sleeping bags and threw them in the river. Another victim's body was left on train tracks and hit. He never dismembered them. Yeah.
I'm sorry, Ms. Cantrell, not on the record. The Zoom link that you.
Yeah. Hello, Indy. Glad you're here. This is a little experiment to see if we want to do trials while I'm working. I'm trying to run the world's longest report here. But I gotta tap out for just a minute. I'll be back with you guys in just a second. Yes, we're just taking a short break here. These breaks usually take 15, 20 minutes. It can be a while. So I will check back with you guys in a bit. Hey, while we're waiting, there's this article that I saw from a few days ago in People. Okay. An Atlanta man has been charged with his wife's murder 25 years later. Her body was found in multiple trash bags. In April of June 1999, human remains were found in separate locations in Atlanta, Georgia, and were misidentified, Atlanta Police Lieutenant Andrew Smith said at a press conference on the 7th. 11 Alive reported that the remains were found in trash bags and the victim had been decapitated. Melissa Wolfenbarger had last been in contact with her mother on Thanksgiving Day 1998, the outlet reported. Her mother, Norma Patton, reported her missing in January 2000, Smith said. So, over a year later, Melissa's husband, Christopher Wolfenbarger, never did. Finally, in 2003, Melissa's remains were properly identified, but it would take another 21 years until someone was arrested in connection with her murder. During the investigation, the Atlanta Journal-Constitution reported that police learned early in the investigation that Melissa hadn't been in contact with her husband since December of '98. In 2000, according to reports from the Journal-Constitution and 11 Alive, Wolfenbarger allegedly told police he had seen Melissa walking down the street in March or April of '99. Christopher was arrested on Tuesday, August 6th, police said, and charged with murder. Tuesday, August 6th, when was this published? This was published in 2024. And charged with murder. He's currently in custody. Again, this is last August in Fulton County Jail. During the press conference, police did not say what led them to arrest Christopher, citing the integrity of the investigation. Detective, oh, hang on. We've got audio coming in. Oh, no. Okay. Detective Jerian Shepard said during the press conference that after he took over the investigation in 2021, witnesses were re-interviewed and evidence was re-examined, but he declined to single out a specific piece of evidence. The detective also noted that Christopher was considered a person of interest from the beginning. No specific motive, blah, blah, blah. There was another one that I saw. Let's see what I got here. Recently closed tabs. Now, where did I put that? Yeah, okay. I'm going to bring this one over here. Let me make sure that it's showing on the screen. Well, sort of. I'm going to bring it in. No, that's not going to work. Okay, it's going to be a little off. But let's read this real quick, okay? How the capture of a serial killer father led to a breakthrough in his own daughter's separate murder case. Melissa Wolfenbarger, or Barger, I really need to learn how to say that, 21-year-old married mother of two, had been missing for 4 years. before her remains were finally identified. But decades passed, and the identity of her killer remained a mystery until now. Crime scene investigator Cheryl Mack McCollum tells Andrea Cavalier how her podcast, with help from experts, the media, and the victim's serial killer dad, helped crack the case wide open. Let's see if we can. Okay. When working on a cold case, there's no guarantee that a murder will be solved, and even if it is, it often takes years or even decades. In the case of Atlanta mother Melissa Wolfenbarger, it took 25 years with the help of a podcast and, in a bizarre twist, her serial killer
You all
father.
please be seated.
Okay.
Good
going
morning,
back.
ladies and gentlemen. Morning. Thank you all so much for your patience this morning as we get through some of our processes that need to happen. I'm going to talk to you a little bit more about how this process will go and give you as much guidance as I can before we get started today. But first, counsel, is this your jury?
Yes, it is, Judge, for the state.
Yes, Your Honor.
Thank you. So, ladies and gentlemen, now that I've told you you could have a seat, if you'll please rise and raise your right hand.
Judge is going to swear him in.
Members of the jury, do you swear that you shall well and truly try the issue formed upon this bill of indictment between the state of Georgia and Christopher Wolfenbarger, who is charged with murder and felony murder? A true verdict give according to the evidence, so help you God. Please say yes if you agree. Yes. Thank you all. Please be seated. So, ladies and gentlemen, thank you all again for your patience. Sometimes things move a little bit slowly, and I promise you that we are trying to be efficient and cautious of the importance of your time and attention throughout this. So, ladies and gentlemen, we are now ready to begin the trial of this case, and I have some preliminary matters
like
that I
it's
want to
gonna-
discuss with you. You'll see me reading a good bit, and that's because there are lots of places where it's good that the judge doesn't ad lib, right? And so I'm going to read some things to you to make sure that you understand what your obligations are and to provide you as much information as I can. as we
Sometimes
get
this takes
started.
like a good hour.
So I've already told you about our deputies. They're an excellent resource for you in terms of asking questions about what the schedule is going to be, where and when you can go or not go. I'm going to try and give you some instruction about that as well. From this point forward, as you just came into the courtroom, you will only enter the courtroom through this door and only when accompanied by a deputy. So that means that when
not
we need
much,
you to
Judge.
leave, the deputy will come and open the door for you and hold it while you go out. And when it's time for you to come in, the deputy will come in and announce your arrival. The deputies can also tell you a bit about our fairly meager offerings for lunch. I encourage you to consider bringing your lunch. We do have some options, but not a whole lot, and sometimes you'll be pressed for time. And I want to make sure that you do have an opportunity to eat and to make sure that you don't get hungry or distracted while you're serving as a juror. So I think all of you are wearing your juror stickers. If you would, make sure that you're always wearing those when you're in the courthouse. And that is for a very important reason. So from now going forward, the people in this courtroom, the witnesses in the case, the parties in the case, they're not allowed to have any contact with you outside of this courtroom while we are engaged in the trial. And so the reason that I ask you to wear those stickers is so that you can be identified as a juror should you encounter someone in the hallway. Now, if that happens, don't panic, just let us know, right? Now, what may very well happen is you may encounter a witness or a lawyer or a party while you are waiting on an elevator. If they go away from you, please don't be offended, right? They're not being rude to you. They're simply trying to satisfy the court's obligation and their legal obligation that they not have any contact with the jurors outside of this proceeding. So we will generally hold court from 9:30 to 5:30. I will tell you each day when we adjourn when you have to come back and what time you need to be back. And I will try to be very cognizant of taking breaks in the morning, taking lunch breaks, things like that, so that y'all will have a chance to have a break from what is the real, mental focus of being here in the courtroom. So, ladies and gentlemen, you have been sworn and impaneled, and you are about to try a criminal case entitled The State of Georgia versus Christopher Wolfenbarger. Before we begin the trial, I'm going to give you some preliminary instructions on the fundamental principles of criminal law, and I'm going to instruct you on the role of the judge, the role of the jury, and the lawyers, and give you an overview of trial procedure. Many of you may have never served on a jury before, and it is therefore necessary that these instructions be given so that you have a general understanding of the procedure in a criminal trial, of what will be expected of you, and how you are to conduct yourself during the trial. The defendant in this case is charged in the indictment with crimes that are violations of certain laws of the state of Georgia. Now, I want to emphasize to you that the indictment, including all of the counts in it, and the plea of not guilty are the legal procedures by which these criminal charges are brought against the defendant. The charges and the plea of not guilty are not evidence of guilt, and you may not consider them as evidence or implication of guilt of any crime whatsoever. This defendant is presumed innocent until and unless he is proven guilty. This defendant enters upon the trial of the case with a presumption of innocence in his favor, and this presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the crime or crimes charged. Now, under our system, it is my duty as the trial judge to determine the law that applies to this case and to instruct you, the jury, on the specific rules of law that you must apply to the facts in arriving at your verdict. Now, I'm giving you some of those instructions now, and I will give you more detailed legal instructions after the evidence has been presented and the lawyers have made their closing arguments. Now, during the trial, I may be called upon to rule on motions or objections to evidence. Nothing I say in making those rulings or at any time during the trial is evidence that I have any leaning in the case whatsoever. My only interest in this case is to see that it is fairly tried according to the laws and the Constitution of the state of Georgia and the Constitution of the United States. Now, as expected, these lawyers serve as advocates for their clients, and they are duty-bound to represent their clients to the best of their ability. The lawyers also serve as officers of the court, and as such are bound to follow applicable laws, trial procedure, and the rules of evidence during the trial. Now, if at any time the lawyers believe that any law, procedure, or rule of evidence is being violated, they're allowed to make motions regarding the conduct of the trial or objections to the admission of evidence. In making these motions or objections, the lawyers are simply seeking to fulfill their duty to their clients and to the court. Now, sometimes those motions may need to be heard outside the presence of the jury, and one of two things will happen. Sometimes you'll see us come over here, as I think you saw us do during voir dire, and we'll engage in a quiet conversation if it can be done quickly, and that's to minimize the number of times we might need you to leave the room. But sometimes those things require us to give it a little bit more time, and so we will have to excuse you to the jury room when we need to do that, and we will just thank you in advance for your patience and understanding that those matters are important when they are occurring. We will try to keep them to a minimum, and again, to be cognizant of the importance of your time. Ladies and gentlemen, trial procedure in a criminal trial is generally as follows. First, the attorneys for both sides have the opportunity to make what is called an opening statement. Now, both sides are entitled to make an opening statement, but neither side is required to make an opening statement. Remember that what the lawyers say is not evidence, but it is a preview or an outline of what they expect the evidence in the case to be. Following the opening statements, the evidence will be presented. Evidence can be presented in the form of testimony that you will hear from witnesses who will take the stand, or physical evidence that will be labeled with exhibit numbers for identification. After the presentation of all the evidence, the attorneys will have the opportunity to make what is called a closing argument. Now, at this time, the attorneys may suggest to you which laws are applicable and how they should be considered in light of the evidence, and point out to you certain parts of the evidence that they think are favorable to their position. The goal of a closing argument is to persuade you to decide the case in their favor. Following the closing arguments, I will charge you more specifically on the law that applies to the case, and I will then ask you to retire to the jury room to deliberate and reach your verdict. The jury has a very important role. It is your duty to determine the facts of the case and to apply the law to those facts. I will instruct you on the laws that apply to this case, but you must determine the facts from the evidence. Evidence, by definition, is the means by which any fact in issue is established or disproved. Evidence consists of two things, either testimony or exhibits. Testimony is the testimony you will hear under oath from those who take the witness stand. Exhibits are those documents, photographs, or physical evidence that are admitted into evidence. Ladies and gentlemen, the object of this trial is to discover truth. And during the trial, the admission of the evidence will be governed by certain rules of evidence. Those rules were drafted with one prominent purpose in mind, and that purpose is the discovery of truth. Now, consequently, the rules of evidence seek to assure that only the best and highest evidence is admitted for your consideration. During the trial, the attorneys have a right to object to the admission of evidence if they believe that its admission would violate a rule of evidence. I will admit or exclude the evidence according to those rules. If I overrule an objection, that means that you are allowed to consider the evidence that is being offered. On the other hand, if I sustain an objection, that means that you may not consider the evidence that is being offered. Now, you should consider only that testimony and only those exhibits that are admitted, and you should draw no inferences and make no assumptions about the evidence objected to if the objection was sustained. Now, sometimes you might see or hear inadmissible evidence before an objection is asserted or before the court can rule on the objection. If that occurs, I may instruct you to disregard that evidence. And if you are so instructed, it is your duty to disregard that evidence in its entirety during your deliberations. You, the jury, must determine the credibility and believability of witnesses. It is for you to determine which witness or witnesses you will believe and which witness or witnesses you will not believe, if there are any that you do not believe. In determining the credibility or believability of witnesses, you may consider all of the facts and circumstances of the case, the manner in which the witnesses testify, their interest or lack of interest in the case, their means and opportunity for knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, and the occurrences about which they testify. You may also consider their personal credibility as it appears to you from the witness stand. As the fact finder, it is your duty to believe the witnesses whom you think are most believable, and it is for you alone to determine what testimony you will believe and what testimony you will not believe. Ladies and gentlemen, it is important that you pay close attention to the evidence as it is being presented during the trial. There are a couple of important reasons for that. Number one, there may be evidence that is admitted and presented to you to observe during the trial that you may not have with you during deliberation. And so it's important that you observe the evidence that is being presented to you when it is being presented during the trial. Also, as I mentioned a moment ago, observing witnesses as they testify is important. And so for that reason, I'm going to encourage you that if you at any time are unable to see or hear, or if you are suffering from some personal discomfort that distracts your attention, to raise your hand, let me know, and we will take a break or do what we can to address the issue with your being able to see the evidence or hear the evidence, or be comfortable enough to focus on the evidence as it is being presented. It is important that you view the evidence, ladies and gentlemen, with an open mind at all times, and that you reach no final conclusions until the trial is over. Do not jump to conclusions before all of the evidence is presented. Also, remember that during the course of the trial, it would be improper for you to discuss this case with anyone or to allow anyone to discuss the case with you or in your presence or hearing. This applies even to discussions amongst yourselves in the jury room or elsewhere before actual deliberations begin. I think you have been provided with notepads, so I want to take a moment to address the issue of note-taking. You are allowed to take notes, but you are not required to take notes. If you decide to take notes, please remember not to let note-taking distract you from observing the evidence in the courtroom as it is being presented. Your observations, as I said a moment ago, of the witnesses during their testimony can be vital to your determination of their believability, and the notes that you take might refresh your memory when you are called upon to deliberate. But importantly, the notes that you take are only to refresh your recollection. They are not evidence. They are only for you to recall the evidence as it was presented at trial. They are memory aids. It is the duty of each juror to recall the evidence, and while you may consider another juror's notes to refresh your recollection of the proceeding, do not rely on or be influenced by the notes of other jurors unless their notes help you in determining your own independent recollection. Notes are not entitled to any greater weight than the recollection or impression of each juror as to what the evidence may have been. Now, that's the conclusion of the introductory instructions that I need to give you. Before I call on the state, I do want to make sure that everyone is aware that the rule of sequestration has been invoked. And if there is anyone in the courtroom who anticipates that they will be called a witness in this matter, I ask that you please exit the courtroom and do not re-enter until you are instructed to do so or called by one of the parties as a witness. I also will just mention again, as I've asked the attorneys, you know who your witnesses are better than I do, and so if you'll just keep an eye out in case they wander into the courtroom so that we can get them out of the courtroom as quickly as possible. And with that, I'll call upon the state. Does the state wish to make an opening statement?
We do, Judge.
Okay, you may proceed.
Opening statements already. Here we go. Just the hearing before has sucked me into this case, man. Just sucked me in.
Good morning.
The politeness of the South.
It's been 27 years since 1998. And specifically, December of 1998. That was the last time that Melissa Walkenbarger was ever heard from. At that point, in 1998, Melissa Walkenbarger was 21 years of age. She was married, had 2 children, had a mother, sister, and after 1998, December, neither one of them ever received a phone call, not a visit, not a card. Not after Christmas of 1998. Not after her mother's birthday in 1999 in February. So you're going to hear that Melissa, at the age of 21, she had experiences when she was a child when she would run away from home. She had experiences during her adulthood after she married this defendant, Christopher Walkenbarger, when she would not talk to her sister for a period of time. But she would always keep in touch with her mother. Most importantly, she never let a holiday go by without calling or visiting. In November of 1998, Melissa had the intent to visit her mother for Thanksgiving. And they spoke. One of the things that Melissa was really looking forward to was getting a photograph of her pawpaw, her grandfather, the father of Carl Patton, Melissa's grandfather. And that is Carl Patton, Melissa's father. And that is the husband of Norma Patton. She wanted that photo. And Norma Patton expected that at some point between Thanksgiving, even though she didn't get an opportunity to go visit her mom, that she would get that photograph. Well, when Christmas came around, she was concerned when she didn't hear from her, but by the time she got to February, she knew something was wrong. Melissa never would let that much time go without talking to her mom, not especially during that period of time, not on her birthday. Well, it took some time for authorities to be alerted, because you're going to hear that Melissa wasn't reported missing until January of 2000. And that was because this defendant, Christopher Waffenbarger, you're going to hear from his own words. You're going to hear what he told the detectives, what he told his children. He never looked for her. He never reported her missing. So when Norma Patton and Tina Patton are looking for Melissa, where is she? She's not working anymore. She worked at Waffle House. She's not showing up to her job. She's not looking after her children. She's not checking on her children. No word. Well, the authorities tell them that, well, Melissa is 21. She's married.
I hate this. I hate what he's about to say.
If she hasn't called you, then maybe she doesn't want to talk to you.
She's an adult. She's allowed to leave.
Her husband hasn't reported her missing. And you hadn't talked to her in a month. Well, not really much for us to do right now. But eventually, Melissa's mother goes to Henry County, and they start an investigation. But even though they talked to friends and family, they even talked to Christopher. And all they get from him is she just left. That's it. That goes on for 3 years. She gets unidentified for 3 years. And that takes us to really when we locate the remains of Melissa Waffenbarger. They were located on 2 different days. April 29th and June 3rd of 1999. Now, April 29th, George McKeitry is driving on the area and heard questions about Avon Avenue. That location is the location of Action Glass Company. You're going to hear that is the location where Christopher Waffenbarger worked. Glass company, kind of a manufacturing plant. They had industrial equipment at this location. That's where he worked. Although they had no reason to think that that was anything significant at the time, because in April 29th of 1999, all they knew was that there was a head in the roadway, partially, fully, pretty much fully decomposed. And Mr. McKeitry George McKeitry is driving on in that area on Avon Avenue, and he sees something that he thinks is kind of odd. So he stops and looks at it, goes and gets his daughter, and comes back, and he can see what clearly is a human head. Now, something that he would tell you he couldn't believe with his own eyes, or what he couldn't believe. Well, that begins the discovery and really the process of trying to identify that skull. That's those same detective, the lead detective at that time was Dale Kelly. You're going to hear from the Fulton County medical examiners, investigators, Tina Miller. They were all out there at that location on Avon Avenue, April 29, 1999, collecting evidence, taking photographs, some of which you'll see. But ultimately, they start looking for information on who this could belong to. Then you find the extremities on June 3rd, 1999. As these extremities are found, everything but the torso, so everything but the midsection of Melissa Waffenbarger is located. Femurs, and you'll hear from the detectives, you'll hear from the medical examiners. When the skull was found, it had a portion of the spine attached to the skull, and it appeared as though it had been severed or removed with some type of circular saw.
A circular saw? What?
The extremities were examined, detectives, medical examiners, the anthropologists that work for the Fulton County Medical Examiner's Office, they observed signs of tool marks. The anthropologist describes the different lines on the bones as what happens when a saw is attempting to catch a groove and actually make a cut. You'll see the bones where there's the saw marks on the finger of Melissa Waffenbarger. You will see the end of the finger where it appears as though you see ridges on the bone where that saw cut. But even on June 3rd of 1999, they even had these cases connected. They were found about 50, 60 feet from each other in that same area.
And they didn't have them connected?
They didn't have a basis to connect it to, so they were in the medical examiner's office as two separate case files.
Okay.
Skull found on Avon Avenue. And extremities found almost 2 months later on Avon Avenue. They suspected that the cases may be connected, but they didn't have what you needed to actually combine and connect the cases and say that they were the same person. But what do you do at the beginning of a homicide investigation? The first thing that law enforcement does, especially when there's evidence of foul play, as in this case, when you find out who the victim is, who the person is, you go look at their background. And what did they find when they looked at what Melissa's life was like when she was alive in 97, 98? Who was she talking with? Did she have conflict with anyone? Is she married? What was her marriage like? Were there instances of abuse in the marriage? Had her husband ever been charged with anything related to that abuse, like hitting her? They looked at that information, and I'll tell you that at the time they did find an identity and were able to determine the identity of skull and extremities, Christopher Waffenbarger was the primary suspect. I'll just tell you that. He was the main person that they were looking at. He wasn't the only person, because you got to conduct a thorough sifting investigation, but they had evidence that Christopher and Melissa were involved in a tumultuous relationship, that Christopher was abusive, that he had struck her on multiple occasions. They had evidence that he had caused a black eye, that she had witnesses that observed bruises on her neck. They had evidence that at some point Melissa applied for a protective order to prevent contact with this defendant. You're also going to hear that on the day that Christopher was ordered to come to court, March 29th, ordered to come to court on July 29th, 1998, you're going to see that same day, Melissa appeared and requested for that case to be dismissed. Roughly 7-8 days after she was hit, 7 days after she went personally and applied for a protective order, 7 days after that, she goes back down to the courthouse and asks for it to be dismissed. I don't want to prosecute her. You're going to hear from a lot of witnesses in this case. You're also going to hear from a domestic violence expert. And that domestic violence expert will be able to explain that that is not uncommon at all. The victims of domestic violence to come back and say, I don't want to prosecute. You're going to hear about some of the reasons why that can happen. And that was the 21st of July, 1998. Officer Marlon Sutton responded to the residents at 824 Brookline Street in Atlanta. That was marital residence of Christopher and Melissa Waffenbarger, the family home of the Waffen-Barger family that Christopher and Melissa were staying in at the time. When Marlon Sutton arrived at that location, it was a response to a domestic violence incident. And when he arrived, he got an opportunity to view Melissa Waffen-Barger, see her in person. What he observed was someone that had bruises, someone that had been attacked, someone that was hysterical and afraid. Didn't see Christopher there that day, though. He wasn't there, he left. So, she was instructed to do as she did.
I'm going to try to find a way, but this is as high as I can get it.
Which is what she did very much day. You want to see those documents you last week. The day after this, she goes down and spots that objective. And by the time this case comes up, on March 1999, you'll see this document, in particular, state court documents, actually filing the formal charge of battery against this defendant, 1998. By the time it comes to the court, they can't find Melissa. Can't find her in March 1999. No way of knowing a month and a half later, her head was found in front of his job. And I'm going to say this too. Less than a minute drive from his house in walking distance. You got this decomposing head here between the night in front of the job at Avon Avenue. And you got the location of Avon Avenue itself. So this is the Action Glass Company location right here. So this is where Christopher Waffen-Barger worked. You'll see this map, and witnesses will explain. Witnesses that were at this location in April of '99 when her head was located. You'll see on the photographs there will be a sewer here, and you'll see where her head is located here. Within about 120 feet from his job. And then in June, you'll see where the extremities, the sawed-off legs of Melissa Waffen-Barger are found in this area. The detectives will tell you when they examined the location, it appeared as though they saw an animal here in a bag, right where the head was located, from this area out onto Avon Avenue. So when they were able to make the connection, they come back with cadaver dogs, and they go back and look in this area, and that's how they find the extremities. That's how they find the June 3rd, 1999 legs, remaining parts that we found. And we never found her torso, but the remaining parts we found was about. It'll give you a perspective of where its job is and where Brookline Street is. This is Action Glass. This is the junkyard where the extremities were found. Here is the location of the sewer where the head was found. And less than a minute drive is Brookline Street where Melissa and Christopher Waffen-Barger reside. Now, in 1999, you don't have the Atlanta Beltline. You don't have these buildings. This area is primarily wooded. But that is the location and the proximity of Christopher Waffen-Barger's job to where his wife's head was found, to where his wife's legs were found, and where they lived. This is a case about domestic violence. In addition to the evidence of the physical bruises on the person of Melissa Waffen-Barger, you're going to hear from her family. Her mother knew about the July 1998 attack. Melissa told her about it. She told her mother how Christopher was upset, wanted her to come back, and how he struck her in the face, how he grabbed her and dragged her by the hair. Nobody was arrested. Her mother was one of the persons that she told about that July incident. You're also going to hear from her sister, Tina Patton, who occasionally worked. Well, one time in particular, in 1998, it was a 2 or 3 month period where Tina Patton, Melissa's sister, worked at a Waffle House. I believe it was Virginia Avenue Waffle House. They worked at a few Waffle Houses that year, Melissa did in particular. But during that period, in the early part of 1998, Melissa and Tina Patton worked at the Waffle House. And she would tell you that there was one day that she observed while she was working with Melissa during that period, she observed marks on the neck of Melissa, around the sides, and she knew immediately it looked, and she'll tell you this, it looked like someone had choked Melissa. And Melissa told her that hey, Christopher Waffle. And you're going to hear from a man that Melissa was seeing right when she died. You're going to hear that Melissa planned on leaving his defendant. You're going to hear from his own mouth that they weren't on good terms when she left, when she went missing. Thomas Dixon was also working at a Waffle House when he met Melissa Waffle. And towards the end of 1998, they started seeing each other. And at one point, Melissa was staying in a lodge or hotel with Thomas Dixon. And he'll tell you that he was fully aware that she was with this defendant, Christopher Waffenbarger, but he'll tell you that she wanted to leave. And then during that week, she was spending with him. She fully planned on doing that, but decided to go back to him, to Christopher in particular, to see her children. She missed them. And Thomas Dixon will tell you that the last time he saw Melissa Waffenbarger, Christopher Waffenbarger came up to that Waffle House. Melissa and Christopher had a talk, and Melissa got hysterical. She started crying. Thomas Dixon will tell you that he went outside to talk to Christopher and told him that he has to leave until 9 o'clock, and she did so. You're going to hear Thomas Dixon tell you that when Christopher left, he peeled out in his Volkswagen, and that was the last time he saw Melissa. He'll tell you that she never came back to work at Waffle House. She never called. She never texted. And that is the evidence to show that that's consistent with what you'll hear from her mother and sister regarding the last time anyone ever saw her. And as I said, she goes unidentified for 3 years. During this period, the medical examiner that is working in Fulton County is also working in Twiggs County, and is first attempting to determine if a headless corpse that they located in Twiggs County could potentially be connected with this skull they find in Avon Road in Atlanta. That was one thing they were looking into. There were several missing persons in and around the state of Georgia that they were attempting to get dental records for and prepare. There were tooth extractions that were done during this period, but all in the attempts to find the identity of the person who that skull belonged to. There were attempts to conduct reconstruction. And what further confuses it is the anthropologist plots skull dimensions on a scale, and you get a range. And sometimes those ranges overlap. So at some point, they'll tell you that her skull looked like it had been run over, damaged, and she, at some point, the anthropologist thought because the skull was male. All this was going on during this period from 1999, April, when they located the skull, June, when they located the extremities. All this is happening during this period, trying to find out who these remains belong to. And ultimately, Melissa doesn't get identified until 2003. And what triggered the identification ultimately is the arrest of Melissa Walkenbarger's father. You're going to hear that Melissa Walkenbarger's father essentially pled guilty to committing murder himself, made multiple murders himself. And when he was arrested, it was a notorious publication, it was a notorious arrest. It garnered a lot of attention. You're going to hear that Carl Patton asked the lead detective when he was arrested after he confessed. He asked the detective, told him that his daughter was missing for 3 years. He had no leads. He asked if he could find his daughter. Well, the detective contacted the Fulton County Medical Examiner's Office. We had this unidentified skull that they found 3 years ago. And with Carl Patton's statement, they obtained the medical dental records from Melissa Walkenbarger's dentist, William Grant. Got a pediatric practice in the 80s and 90s. He obtained Melissa's original records, x-rays, and they gave Dr. Mary Beth Hopkins, forensic dentist, the medical examiner's office, conducted an examination, looked at the x-rays, looked at the fillings, looked at the dimensions of the teeth, and was able to make a conclusive determination that the skull that was found in April of 1999 was in fact the skull that belonged to Melissa Walkenbarger, that the dental records matched the impressions that she took from the skull. It was a match. That's when all the location of the job, that's when all the location of the house, the location of the extremities, and the skull between the job, that's when all that comes in. And that's already a suspect. But that's when they're really focusing on this. You know what he says? Same thing. She just left. Then he says, oh, well, I dropped off at the train station. You're going to hear those statements from him, and you're going to hear the detectives question him about those statements and that explanation. As I said, the skull is identified by Mary Beth Hopkins. There were 2 medical examiners during that period in 1998 when we first started, from 1999 when we first started their examinations. Dr. Carol Terry and Dr. Joseph Parker. Dr. Joseph Parker is no longer living, but you will hear from Dr. Carol Terry, who will tell you that she examined the extremities. She'll tell you that she examined the skull and that they appeared to have evidence of tool marks. And she'll tell you that her expert opinion is that Melissa Walkenbarger was murdered. The circumstances of her lifestyle, with how she was living, what was happening to her, the circumstances of her remains, the condition that they were found in, makes it highly likely that she was murdered. That's what she'll tell you. Tina Patton is the sister of Mrs. Walkenbarger that you will hear from at some point today. Melissa told her that Chris was responsible for the bruises on her neck. You'll hear from Norma Patton, Melissa's mother. She was told about the battery in July of '98. Melissa told her mother that she wanted to leave this defendant. She told him that he was abusive. You'll hear from Thomas Dixon, who Melissa was in. Probably one of the last persons that Melissa saw. He also has information that he's going to tell you about how abusive this defendant was from Melissa's own mouth. And you're going to hear from Christina Garrett. Christina Garrett is the daughter of Melissa Wolfenbarger and Christopher Wolfenbarger. And the one thing she'll tell you is that she recalls her mother. And one thing that kind of stood out is she just remembers her mother kind of disappearing one day. And she'll tell you that one of the oddest things that she cannot reconcile is almost immediately after Melissa just vanished, this defendant essentially just removes all of her stuff out of the house. You can see the pictures of mother, belongings, and things of that nature. She's gone. While she was growing up, she would constantly ask him, "Where's my mother?" And you would expect that you would have heard an answer at some point, some type of explanation, where she would tell you that he never answered her question. He never told her I looked for her. He never told her I ever reported her missing. Nothing. In fact, she would tell you that this defendant would tell her while he was growing up that he knows how to get rid of a body. He knows how to not get caught. He also told his daughter, and you will hear this from her mouth, that he had a place to go on the run if he needed to. Now, Christina Garrett, Christina Wolfenbarger, grew up in basically being cared for by Kathy Wolfenbarger, Christopher Wolfenbarger's biological mother. She lived in the house until she was able to leave when she became an adult. You're going to hear that when she left the house of grandmother, when she was able to get out on her own, that's when law enforcement gets that information from her, around 2015, 2017. That information about what he told her while she was growing up. You're going to hear from Dorothy Jones. Now, Dorothy Jones is a resident of that neighborhood at that around that 800 Brooklyn Road area, close to the Action Glass Company where Christopher Wolfenbarger worked, close to the location where Melissa Wolfenbarger's skull was located, close to the location where Melissa Wolfenbarger's remains were located. Dorothy Jones is familiar with that location, and essentially what she's going to tell you is she pretty much hung out with Christopher pretty much every day during that period. She remembers him. She remembers Melissa. She remembers seeing signs of Melissa being abused. She would tell you that she saw Melissa with the black eye herself, that she had been punched in the eye. She's also going to tell you that she's heard them fighting at that house, glass breaking. Probably the most disturbing thing she's going to tell you is that she saw him every day for about a 10-year period. And just one day, Melissa was gone, never saw her again, and Chris was gone. And she says, not only gone, but just kind of left all this stuff. It's in there. You're going to hear about the signs of trauma. There are going to be some photographs that you'll see solely for the purpose of illustrating the tool marks, the mechanical device that was used to disconnect the limbs of Melissa Wolfenbarger. And most importantly, you'll hear this defendant's own statement. During that 1999 period, he told the officers that he was fired because the owners thought he stole a saw. He admits to borrowing it. He admits to using it to pick the top off his car. They never got the saw back. And you'll hear from the anthropologists, the detectives, the medical examiner, that there are signs that Melissa Wolfenbarger's remains have been solved. You also hear about the day he was arrested. 2024. And it did not go like a typical execution of a warrant for homicide, because it took quite a bit of time to locate this offender. In fact, they didn't locate him in the residence portion of the house. They located him in the side area of the garage that was situated in the living space. They found him in a something that looks, the evidence will show that it has the appearance that it was created for the purpose of the crime. That's what the evidence is going to show. After about 40 or 50 minutes, they get the dogs, and you just can't hide from the dogs, right? The dogs hit, come on out of there. You see, that's what you're going to hear. When he crawls out of there after an hour, and evidence is going to show he knew exactly who was at his front door. In your determination, your decision as to why, I submit to you, it will be clear why. It will be clear. They were there to finally arrest this defendant for the murder of his wife. Arrest this defendant for dismembering his wife. They were there to arrest him and hold him accountable for taking Melissa Walkenbarger from her mother and sister, most importantly, her children. At the conclusion of this case, the evidence, testimony, the exhibits, you will be left with one decision, and that's to vote the truth. And I submit to you, the truth will be guilty on both counts of the state indictment for the murder of Melissa Walkenbarger in 1989.
Thank you. Mr. McDermott, does the defense wish to make an opening statement?
Yes, ma'am.
Okay, you may proceed.
We can all agree that Melissa Wolfenbarger did suffer a tragic death. And you haven't yet heard the extent of which she had suffered a tragic life. But the extent of her suffering in life and in death had nothing to do with Christopher Wolfenbarger. The state's story begins correctly. This is a case about a horrifying discovery of human remains that later became identified as Melissa Wolfenbarger's. But the evidence will show you over the next few days that the state's story has gaping holes in it. And that the state is going to ask you effectively to imagine in order to connect the dots between those gaping holes. To fill the gaps, if you will. What the state has declined to tell you in this case is far more important than what they have told you. And your job over the next few days is going to be to see those gaps, to refuse to imagine, and to demand proof of all the elements of the crime that is charged beyond a reasonable doubt. You're going to hear evidence, some of it from their own witnesses, that multiple other individuals could have had something to do with Melissa's death, starting with her own
So the main
parents.
defense is alternate theory.
You've heard mention already of the Flint River murders. Melissa's father, Carl Patton, committed a string of murders in the late 1970s. He was suspected of those murders for a long time. He was investigated, but they were not prosecuted and proved until 2003, 4 years after Melissa's disappearance and death. You'll be presented with evidence that Norma Patton, his wife, helped him directly commit at least 2 of those murders, to dispose of the bodies, to clean up the crime scenes, and to wrap up the bodies and dispose of them in ways that are somewhat similar to the way Melissa's remains were found.
Sleeping bags versus garbage
Carl,
bags.
Melissa's father, died in prison last December. Melissa's father eventually confessed to killing 5 people. Some of those were for personal revenge. Some of those were contract killings for money. And at least 2 of those were murders of his own friends because they knew too much. All of the victims were either close friends or family members. In one case, Carl knew how to stage a crime scene. He turned what was a shooting to look like an accident of a car on train tracks.
Your Honor, I object to the defense's content of their opening statement. The statements made by counsel are just simply irrelevant to any issues that are presented during this trial.
As previously discussed, they're going to be relevant to third-party guilt and the motive story.
I'm going to overrule the objection on relevance grounds. I am, however, going to request that you, in line with our earlier discussion pre-trial, limit some of the details unless and until that evidence is presented to the jury.
I will not get into any more granular detail than I have so far.
Thank you.
Satisfactory?
Yes, sir.
Melissa's mother in 2 of those murders was a co-defendant. She confessed to planning 2 cold-blooded murders, cleaning up the blood, bleaching the floor, etc. And the murders from which
What a place to grow up in.
That comes to those murders is the Flint River murders, is because one of those bodies was dumped in the Flint River, the other in the Altmoultrie River. And the only reason Norma didn't go to prison like Carl did was because she got immunity to testify against him. And she'll be here to testify this week. The evidence will show that there is also a Patton family associate who also had very strong motives to kill Melissa. For trying to get him prosecuted for allegedly molesting her in the 90s, and also because his father later turned out, to his knowledge, was one of Carl's victims. And until he learned that, he was a family friend and hung out with the family. And that man's name is Eric Martin Jackson. You'll find out later that at some point Martin learned what Melissa's father had done to his father. And he goes and buys a series of burial plots at a cemetery in 1997, a year before Melissa goes missing, or maybe a year and a half. And he buys them in the very cemetery that Melissa is buried in today. And later, because later he sold those plots to her family. And there are others I'll touch on in just a minute. We expect Norma Patton to come here and testify that she had a loving relationship with Melissa, that Melissa loved her, communicated with her, stayed in touch with her, tried to get away from Christopher's control every chance she could get, so she could come back to Norma's home and see her. But the evidence is going to show that Melissa was actually abused by her mother in her own home for many years and started running away frequently. Her mother locked her in a room all day, every day, from roughly ages 7 to 12. The evidence will show that their home was so foul and dirty that Melissa acquired a foul smell in her clothes and hair that made the other kids at school bully her and tease her. You'll hear evidence from Melissa's next-door neighbor and childhood friend that she will detail the abuse that she endured in that house. Moreover, at some point before Melissa ran away, her sister Tina had a pregnancy in that house, delivered the baby in the house secretly, and tried to dispose of it secretly in a clothes hamper in the house. 13-year-old Melissa discovered that baby's corpse. She eventually told school officials, who later called the police, And it was at that point that Melissa began running away from her home regularly. Christopher, in fact, first met Melissa because she ran away from home. And through a mutual friend, they met at that mutual friend's house. Now, Christopher and Melissa eventually got married, and they did so fairly hurriedly. They were both 17 when they got married. They had 2 children, very young, in very close succession. When Melissa was still pregnant with her second child in 1996, she went to Christopher's mother, Kathy Wolfenbarger, who will testify that Melissa asked her if she would take custody of their children temporarily. And she did. When Melissa got in some legal trouble the next year in Gwinnett County and went on probation for theft, it was after that they began to, that's when they moved up to Brookline in July of '98. Their children lived with Christopher's mother in Stockbridge and later in Locust Grove, Georgia. When Christopher and Melissa moved up to Brookline in 1998, the children did not go with them. Now, you've heard some talk about an incident that happened in July of 1998 when Melissa took out charges against Christopher. You also heard the state tell you that Melissa came back and dropped the request for that protective order. What they didn't tell you is the very next day, Melissa calls Kathy Wolfenbarger from the Henry County Superior Court and asks her to please come down and sign the papers to make her custody of those children permanent. To make Kathy's custody of Melissa's children permanent. And Melissa permanently relinquishes her parental rights to those children. One of the reasons Melissa originally gave for giving her children over to Kathy Wolfenbarger, and she tells this to Kathy, and she tells this also to Christopher's sister independently, was that she did not want her parents to have anything to do with her children because they are bad people. After relinquishing her parental rights, Melissa quit working around that time at the Waffle House in East Point with her sister, and for some reason begins randomly working at a Waffle House clear up in Doraville. No one knows why she went up there. According to everyone, no one had any connections up there, friends or family or anything. But she goes up there and starts working. Melissa started spending more and more time in Doraville, days at a time, working double shifts, spending the night at someone's house, and then multiple days, and days turned into weeks, she would be gone from Christopher's house. And it was at that time that she had started seeing Thomas Michael Dixon, the state mentioned a while ago. We'll have a chance to cross-examine him. In October of that year, Melissa got arrested in Gwinnett County for violating her probation, and she spent 30 days in jail until early November. The terms of her probation required her to do community service. This was outstanding from 1997, still in effect. She was to do community service, she was to take GED classes, and she was to report regularly to her probation officer, and she had not done any of that. And so they arrested her, gave her 30 days in jail, and then released her back on the same terms of probation. Within 1 month, she is already violating her probation again. Although she was not rearrested at that time. So at this point in her life, Melissa was spending as much, if not more, time in Doraville as she was at Christopher's house. She only occasionally came back to see Christopher. She had her own job. She had her own money. She had her own circle of friends. She had her own freedom. She had no obligations to her children. And so when in December of 1998, she did not come home for several weeks or months, Christopher could safely assume she had decided to live her own life on her own terms, wherever she decided to live. Moreover, if Christopher had raised a stink about it at the time, Melissa was in violation of her probation. She would have been arrested. Melissa's mother, Norma, is expected to testify variously, as you've already heard, that when she didn't hear from Melissa at Christmas in 1998, that's when she knew something was wrong. Alternatively, however, she will testify that no, it was not until my birthday rolled around. That's when I knew something was wrong. She will tell multiple versions of this story. In one version of the story, well, let me back up. The evidence will show you that in multiple versions of the story, whichever version she tells, she never reports Melissa missing until 2000, January of 2000. If something was wrong in December of 98, something was wrong in February of 99 on her birthday, something is wrong a month later, a month later, a month later, her mother doesn't report it. She doesn't file a missing persons report until 2000. The human remains in this case, as you've heard, were found on Avon Avenue. It's an industrial area near the west end of Atlanta. The evidence will show that it just so happens Melissa's father, Carl Patton, was familiar with this area. He grew up in a childhood home on Main Street in College Park. It's just a few miles down the road. Further, the evidence will show that Norma and Carl actually went up to Brookline Street right after her birthday in February of 1999. They found Christopher's empty house at that time. They learned from a neighbor that Christopher had moved out sometime between Christmas and New Year's. They also learned that from that neighbor that Christopher worked at Action Glass down on Avon Avenue. So they drove down to Avon Avenue and talked to the people at Action Glass. And they learned that he had been let go there. Again, this is February 1999. Carl and Norma Patton knew where Chris worked and where he lived months before the head was found on Avon Avenue, right beside where he worked. The state is correct that Melissa's mother and sister are going to testify against Christopher. They're going to blame him. They're going to call him a domestic abuser. But there's a lot of context you don't know. Keep in mind, as we've already said, the evidence is going to show that Melissa only met Christopher when she ran away from home. The evidence is also going to show you that Norma Patton has consistently, out of her own mouth, stated that she absolutely hates Christopher. From the very first time she ever saw him, she hated him. She worked and did everything in her power possible to prevent Christopher from seeing Melissa. When he was 16, would not let them date, or tried to prevent them from dating. Tried to prevent Melissa from leaving the house. Tried to prevent them from getting married.
Seems like she knew something.
Melissa onto birth control so that she could not get pregnant. Melissa's older sister joined that opposition to Christopher as well. You'll hear it admitted from her own mouth that she did not like Christopher. No one in her family liked Christopher. And that she tried everything she could perpetually to intervene in Christopher and Melissa's marriage to get Melissa to leave Chris. The evidence is going to show that any claims of abuse or bruises on Christopher's part only began to be generated after Melissa started working with Tina at Waffle House. And the evidence of claims of abuse only come from witnesses who came under the influence of Norma and Tina. Christopher and Melissa, as I said, had 2 children, Chrissy and Joey. Chrissy was born in August of 1995, Joey 11 months later. Again, the state is going to present testimony from Norma and Tina, who will say that Melissa would never under any circumstances have abandoned her children. She would not have just left and never kept contact with her children. Impossible. But we already know that, in fact, she did legally abandon them.
That's a
And the evidence will show that she also
pretty bad argument.
practically abandoned them. As I said earlier, when Christopher and Melissa moved up to Brookline Street, the children didn't come with them. They stayed way back in Stockbridge. The children were raised by their grandmother, believing that she was their mother. In September of 1998, when Melissa started leaving for large portions of the time with her work friends and her new lover, Thomas Dixon, she rarely returned to Brookline Street, where Christopher was. She even less hardly ever went down to Stockbridge. You will hear testimony that she rarely visited her children during this time, and that she rarely ever even called them during this time. Whatever Melissa's own personal aspirations might have been in regard to her children, the one thing we do know is the evidence will show that she rarely ever contacted them, and all but forgot about them. You'll hear testimony from Christopher and Melissa's own daughter, who's now grown up, of course. Her name's Christina. Some call her Chrissy. She will testify as a state's witness. She will say that she remembers to the day when her mother disappeared and all the pictures and belongings were moved from the house. Again, the evidence will show that she didn't live in that house. She lived in Stockbridge. The evidence will show you that at that time, Chrissy was every bit of 3 years old. Moreover, Christopher and Melissa's children didn't live in that house, as I said. Chrissy will also tell you that years later, she remembers Christopher making these offhand comments about he knows how to get away with murder, and the key is to hide the body, or to put it under the foundation of a house that's being built so they'll concrete over it and no one will ever find it. And there are various versions of that story. Christopher's son, Joey, who's also now grown up, will also testify, and he will say he was in the room when such comments were made. And that Christopher was speaking in the context of the boasts that Carl Patton used to make, who was a no-killer. We'll have evidence in this trial that early in their relationship, Carl hired Christopher to help him in the roofing business. Chris spent time around Carl and heard him say these things. Even Chrissy will admit that when Christopher made such comments, it was contextual within a discussion and had nothing to do with Melissa whatsoever. Chrissy will also admit that everything she knows about the case, she learned from Norma Patton. Remember what I said at the outset. The state's going to present little points of circumstantial evidence, and they're going to ask you to use your imagination to fill in the gaps. Here are
That is
some
the nature of
gaps.
circumstantial evidence, of course.
The state will not present any evidence of a cause of death. The state will not present any evidence of a murder weapon. The evidence obviously will show that there were remains that were discovered and that there were marks on the bones. But those wounds are all post-mortem. The state will present you with no evidence of how she died. The state will present no evidence of when she died or where she died. The state will present you with no evidence of where she was dismembered.
They found
Or
pieces
when
of
or
her,
how
John.
she was dismembered. They won't present any evidence of how she was transported to the site in the condition that she was. The state will provide claims about a saw that went missing from Christopher's work, allegedly around the time that Christopher was there. No evidence will show, even though the state claims otherwise, that he stole a saw from them, or that he was terminated for that reason. Furthermore, there's no proof that the kind of tool that actually made the marks on these bones was a saw. If so, what kind of saw? We have no evidence of what type of saw it would have been. We've got no evidence that will show that markings are distinctive of this reciprocating saw that was taken versus the circular saw he mentioned when he started his story. Furthermore, your common sense will tell you that there are about a literal million saws in the state of Georgia. Anybody can access a saw. Anyone can access a wide variety of types of saws. You'll hear from investigators from the APD. They will admit that once Melissa's remains were identified, they searched Christopher and Melissa's house on Brookline Street. They searched every inch of the home, inside, outside, every room, basement. They sprayed the entire house with a reactive agent that discovers drops of blood. Not a single drop was found. They took paint samples from every room. Why? Because when Melissa's head was examined, there were chips of paint in her hair. There were synthetic fibers in her hair. And forensic evidence will show that. The fibers were, in fact, found to be consistent with some kind of a bath mat or even a carpet. Very broad category. When Melissa's remains were the paint samples of her remains did not match any of the paint samples from Christopher's house. There was no match of any fiber from Christopher's house. A pubic hair was found on Melissa's remains. Christopher willingly submitted his pubic hair samples. They didn't match. Head hair samples were found. Christopher submitted head hair samples. The head hair samples didn't match. The medical examiners in this case made DNA analysis of the head almost impossible because one of the medical examiners or anthropologists soaked it in bleach. But the technology still won out in the end. The plastic bags in which the remains have been kept were recently re-examined using the most powerful DNA testing available in modern times, detecting trace amounts of DNA. And sure enough, one of those bags returned a profile that was viable for testing against subjects. It said that there were at least 5 human contributors touching this bag. 2 of them were male. Christopher submitted his DNA. It didn't match. So the state has some huge gaps it needs to fill. And here's how we anticipate that they're going to try to fill that gap. We expect the state will also call a witness who is somewhat of an expert in the area of domestic violence or abuse. Perhaps you think, well, there's no DNA, there's no fiber evidence, there's no trace evidence in the paint chips. The really important evidence must be in the domestic abuse. But just as with the DNA and the paint chips and the fiber, etc., the expert will offer no support for the prosecution's theory in this case, and here's why. She doesn't know anything about the case. She's never interviewed Chris. She's never read a single police report. She's never even talked to the DAs about the facts of this case. Instead, she's simply going to say that she is a domestic violence expert and tell you signs and symptoms of domestic violence. We anticipate that their testimony on those matters will do nothing to prove that Christopher Wolfenbarger is a cold-blooded murderer. She doesn't know anything about him. She knows nothing. And we will ask you when trial is over to reject that level of fake expert testimony. Another thing, the state's going to offer evidence to say Christopher was the last person to see Melissa alive. In December of 1998. You've already heard it. But other evidence is going to show that Melissa's sister Tina actually saw her the following spring. At that time, Christopher had already long moved out of the area. Although Carl Patton was serving 5 life sentences in prison throughout this whole period up until he died last December, that did not stop Norma Patton from firmly expecting he would be paroled at some point. And she began looking into his parole within about 12 years after his life sentence had been served, his first out of 4 or 5. And the law technically at the time allowed for someone serving a life sentence to be eligible for parole after 14 years of service in prison. The evidence is going to show you that Norma operated on the belief that the only reason Carl had not been paroled was because his son-in-law, Christopher, had not yet been arrested. She will state explicitly out of her own mouth in a police interview that she believed that as soon as Christopher would be locked up, her husband would be released to come home. And she worked tirelessly for years with the DAs, with the police, and with media campaigns to make sure that happened. Ironically, the evidence will show that the investigators spent hardly any time at all investigating these other potential suspects. No hair samples were taken from them, no DNA samples were taken from them, no pubic hair samples, no searches of their homes, no paint chip samples taken from their houses. No one took DNA samples for this reason from the sister or the accused molester in her home or the friend down the road or anyone else. The evidence will show at most that Melissa somehow died and that someone tried to dispose of parts of her body. The evidence will show that everything beyond that is speculation and imagination. The evidence, as I said, won't show you a cause of death, a weapon, an instrument of death, an incident that led to her death, who dismembered or transported or scattered her remains. There will not be proof beyond a reasonable doubt in this case. There's no DNA, there's no high-powered technology, there's no expert testimony, there's no fiber evidence, no surveillance, no snitches, no co-conspirators, no confession, no eyewitnesses. The evidence will show that the state expects you to fill in all those missing gaps with your imagination. There is no evidence of these charges in this case, and that's why we will ask you at the end of this case to return a verdict of not guilty.
Thank you. Ladies and gentlemen, it's about 12:15, and so we are going to break for lunch, and when we return, we'll begin the evidence presentation portion of the trial. So it is 12:12, we're going to call it 12:15, and break until 1:15 for you to get lunch. Jurors are excused if the deputy will please escort them out of the room.
All right, for the jury.
All right, I'm going to turn that down here real quick. Hey guys, you guys know that I'm working while I'm doing this, and so I've been, you've probably heard some sound effects from my copy and paste system. I What was I going to say? I just a couple of comments, and then I'm going to keep on working, and we'll wait for them to come back from their break. It'll be a good hour. I probably will take my own break. A couple things that I thought. Oh, hang on.
Not from the state.
Not from the defense.
Okay, we are excused. If y'all, I don't know what the plan is for witness presentation, but do we need to resolve the photographs issue when we return from lunch?
Yes. We did.
Okay, so that's, after I said, I apologize, after I said you're excused, I realized I actually need you guys to come back at 12, I'm sorry, at 1 instead of 1:15, so that we'll just have a few minutes to talk through those issues. Thank you all. We are in recess until 1.
Okay, so they're going to have a quick little hearing. I don't know if they call it a hearing before they get back to presentation of witnesses. But a couple things that I thought were pretty darn good from the defense. Okay. Number one, goodness, let me just mute that real quick. What I think he did a good job of is trying to demonstrate that there was direct evidence that was missing, right? And he pointed out that this was a circumstantial case. It's very easy to get lulled into a false sense of, I guess, that there is no case if it's circumstantial. I say this all the time on my channel. Most evidence brought before a jury, in my experience anyway, is circumstantial evidence. As it piles and piles and piles up, it starts to create a picture from which the jury can infer things. And it actually is a very good tool for the prosecution because the imagination of the jury gets to go wild. So that is why the defense focuses on no direct evidence in this case. I thought he did a good job of it. I thought he did a pretty darn good job of it. I think that as the evidence starts to pile up on this, we're going to see that he has a lot of nothing to work with. All right. So what I'm going to do is I'm actually going to keep on working, and we will see you back here about 1 o'clock when they come back together. All right, guys. See you then. Looks like we might be coming home or coming back pretty quickly here. I am back and can't wait for the next portion of this trial to start. This is a fascinating one. The whole connection to the Flint River Killer is so wild, and the fact that Mac McCollum doing a podcast on the case is what kind of reignited everything is pretty amazing. Like sometimes I just really love the true crime community. We are often what am I trying to say? Accused of just liking to watch or consume horrible stories, but that's not the case. We'd like to solve crimes too. In fact, that was the name of the first channel I was on with my buddy Rick. We want to make a difference, right? We want to solve crimes. So hopefully we're going to begin here shortly. By the way, I'm also seeing some comments about the glamour shot. That glamour shot is amazing. I grew up. Let's see, just to give you an idea of what my age is. I was born in '75, graduated in '93, and man, these were all the rage. I never had a glamour shot myself. I kind of felt like that was a thing for my sisters and my friends who were girls. But yeah, that is a classic 1990s glamour shot. And I'm here for it. I think it's amazing. I'm all about it. So, yeah, I like it. Okay. A couple questions that came in. Let me just change my screen here real quick. Somebody asking me what's going on with my day job. I am working today. I am not off from the old day job. I am working today. So while I'm watching this and doing this in the background, I'm writing reports. That's what I do. Here we go.
They've got a few minutes to get here, but so I've had a chance to look. Madam Court Reporter, we're ready to go on the record after we get Mr. Wolfenbarger. Thank you, sir.
You may have 2 days of witness. Let's see, listen.
Just so you guys know, the sound is turned off on the. Oh, look at him wheel himself in with his feet there.
Okay, we are back on the record after
here we
our
go.
lunch break. Mr. Wolfenbarger is present. And see about resolving, giving y'all rulings on the photographs issue. So during lunch, I had an opportunity to review the email
We're back on
that
the record. Sorry, my
Mr.
sound, guys.
Fawcett forwarded to me. That was an email from Mr. McDermott regarding his objections to certain photographs. I've also had a chance to review the flash drive that was provided to me, which was a PDF of the various photographs, most of which are not objected to. I think my understanding is that the state had attempted to limit the photographs to some extent, and that Mr. McDermott was accepted that many of them that are in the PDF would be admitted, and that the ones we have still pending as objections have been identified by Mr. McDermott specifically by number. And so I'd like to just sort of take them up in turn. And understanding that the baseline here is these are gruesome photos because of the nature, the manner in which Ms. Wolfenbarger's body was disposed of, and that the manner in which the ME does its work and documents its work, that those things are necessarily gruesome and graphic. And so the question then becomes, are they relevant? And if they are relevant, are they overly prejudicial or for some other reason cumulative, et cetera? Mr. McDermott, if you want to start, I think your first one was photo number 35.
I'm trying to locate the file that has all
Sure,
we're talking about.
that's fine.
I seem to have lost the email. Oh, I remember. Now I have that in the folder. Give me just 1 minute, please.
Yes, sir.
Okay, and the number again, please?
35, which, so it seems to me, and correct me if I'm wrong, but it seems to me that at least the first few that you're objecting to, 35 through 51, 53, you might have additional objections, but it also seems as if your objection is to them in that clinical context, in the medical examiner's possession on like a white table, as opposed to, for example, Exhibit 16, which is also a photograph of the head that was recovered, but in the field as it was discovered.
Yeah, I just felt that, I don't see what that adds. It's not necessary to complete any part of the medical examiner's testimony, and I think it's just cumulative in that sense.
Okay. As we move on to 39 through 42, which again, I think it's fair to describe as sort of various photographs of admittedly a body part that I actually can't recognize by what it looks like.
Which one, the first one?
39 through 42, I just have them labeled generally as body parts. One of them might be a leg, but I don't know what I'm looking at because
she can't determine
I don't
by
have the
what
training,
she's
so.
looking at it. By looking at
So
it,
again,
what it is.
We have pictures
Wow.
of body, I think that exact body part in the field. We have a picture of the black bag just like that already in the field. I don't see what it adds to the medical examiner's testimony to show the same photograph in the same way, just on a different table instead of the ground. So I just think that's cute.
I hope she rules against this.
Okay, so I did look through all of the photographs, and although I did note there's a relatively close-up photograph of the head, Exhibit 16, in the field. I saw distant photographs and closer-up photographs. Maybe 21 is a closer-up photograph, but the rest of them seem to be in the field, seem to be in plastic bags, as opposed to the actual body part that was recovered from inside the plastic bag. Yeah, the 21, I agree with you, does appear to be one body part that was not housed in a bag, and the photograph is taken of it in the field, and it's a close-up. The rest of the photographs that I see in the field seem to either be not close-ups or of plastic bags. And correct me if I'm wrong, Mr. Fawcett or Mr. Wilson, but I assume that the state's evidence is going to be that these were recovered.
I'm not sure why he's
to
in
the
a
extent they were
wheelchair.
in plastic bags at the scene,
Probably just to get
enough to ensure there were body
sympathy
parts
from
in
the
it, and then
jury.
it was the medical examiner's job to remove those bags?
That's correct, Judge.
Okay. And what about Mr. McDermott, 44 through 47?
Same objection.
I hope she rules against this. That's not cool. The jury should be able to see.
And then 50, I don't even know what 50 is. Is it a tooth?
I believe that's, and this is from me talking to Dr. Terry, and
Yes,
she
sir.
wasn't even certain. But she thought it was like a top of the leg at the knee, and that's the cartilage between the knee joints, but maybe,
Okay.
maybe not.
Okay.
It's crazy that they don't even
This
know
was-
what they're looking at. It's so
Maybe because I don't know what it is or didn't recognize it upon seeing it. Probably the
Decomposed.
least offensive of the photographs that I saw.
Gory, it's almost like, rock collecting or something.
Right, but what is the nature of your objection to that particular one?
What does that do for the medical examiner's testimony? Because we're trying to get to the nature of the charges in this case.
Mm-hmm.
What does that lend to, relevant to her testimony toward those charges? I don't see any necessity. So we've got just one more body part, it's random, doesn't really apply to anything. We don't even know what it is.
And she wasn't even sure. What were we talking
I'm fine with removing that one, Judge.
Okay. We will remove 50. Okay. And then we move on to 51, which seems to be a collection of the various body parts. Is this after cleaning or before?
I think that this is before cleaning. I think that is before, Judge.
Okay.
Oh, well, clearly some of the bones have been stripped of any flesh that was on them. So I think you're looking at some of,
Well, that's why I asked the question. Do
you
some
talking
of those bones, did they have flesh on them when they were collected? I don't know.
I'm not aware from any description of what was collected in the field or taken from the bags that they were just bones when they came out.
Okay.
So I think these are all, or at least the ones that are just bones here, have been stripped by the medical examiner.
Well, certainly, I don't know why the top portion of the leg, I don't know why that would be, why that wouldn't be stripped, and the ones at the bottom would. But I know that some of the testimony that I expect is that there was at least one animal that had gotten to the bag. There was the possibility of other animals, because the body parts were out there in that wooded area for several months. And I would say in hot conditions, which one thing that doctors will say is they can't, because of the conditions and the variables, they can't say what rate of decomposition there was. And the other point I would say to that is there's going to be some manipulation of the remains so that the medical examiner can examine and look at potential damage. For instance, I don't find anything particularly gruesome about just looking at a bone itself, especially one that's been stripped of flesh, if that's what indeed happened. But the bone in the condition that it is in the photographs when they examine it allow them to see the damage to it. That's what allows them to see the appearance of assault, striking the bone. So for that reason alone, that visual image should be allowed to be displayed for the jury. aids the testimony of the expert, and it allows for that expert to explain why they believe there are signs of assault on the bones of Melissa Parker.
Okay. And then I have 53, 54, 57, and 59, which at least to my untrained eye, in the absence of evidence, seem to me to be an effort to document alleged saw marks, tool marks on the bones.
Yeah, and I was trying to make an effort to include at least one example of each one of those that's independent. But where they're double pictures of the same thing, I think that's cumulative and unnecessary. That's also why I think that, you know, we've got these close-ups where there are tool marks. That's why we don't need a whole table with the bones laid out. That you can't see any tool marks from that distance anyway. That's just cumulative and gory for no other reason. Doesn't document anything the medical examiner did except take the flesh off the bones. But, and maybe I missed one, that's fine, I'll hear about it. But as far as going through the list, I tried to include one example of each specimen that had tool marks that was unique. And I only object to the ones I thought was cumulative.
Okay.
Yeah.
Just one second, Mr. Fawcett, because I am going to let you respond. So to be clear, I didn't just limit my review to the numbers that Mr. McDermott mentioned, right? I was looking at them as, trying to take them as a whole with particular attention to the ones that you had asserted, looking for things like needless accumulation that would just be gory for no reason versus particular reasons. Again, without any context, I don't know if, for example, 53, 54, 55, 56, 57, 58 are different bones with saw marks in them or different angles of the same saw marks on the same bone.
I can't tell you with definitive accuracy, but my inclination was 54, 55 were the same, just different angles.
And Mr. Fawcett, the point of my asking that question is I believe that the presence of tool marks and the demonstration of them is relevant. Nobody's going to enjoy that process, but it's relevant and needs to be presented. If it is different bones, right, saw marks on multiple bones, I don't think that's cumulative. If it is, unless you anticipate that the medical examiner is going to say that there is a specific reason for two different photographs from, say, two different angles or something like that of saw marks on the same bone, then I would ask the state to endeavor to further limit the photographs.
Yeah.
So to Mr. That's okay, sorry. So to Mr. McDermott's point, if it is three angles of the same saw marks on the same bone, then perhaps one would be sufficient unless you're going to tell me that the medical examiner has a particular reason for having taken that photograph in the manner at which it was taken in order to enable them to conduct their examination.
In light of that, Your Honor, I would propose taking out Exhibit 55, 58, and 59. I believe that would eliminate, and you know, the intent of including 55 and 54 was that the different angles I think would aid the testimony, but I think that the expert can testify based off of the one photo. So I would propose taking out 55, 58, and 59.
Okay. So
Your Honor, did I already object to 53?
you did?
Okay. I'll wait till, did we talk about that one yet?
No, I wanted to start with the saw marks because it appeared to my eye that your point was that, and I thought that was correct, that there were multiple angles of the same saw marks on the same bone, and absent some particular showing of necessity of multiple angles of it, I wanted to see if we could pare that down. Now, going back to the 53, really it's the group of photographs from, say, 39 to 53, which are the various body parts. As a general proposition, their existence and condition in the field is relevant and admissible, right? Those photographs that document that, as long as they're not cumulative, as long as we don't have 7 photographs of the same thing. I believe that starting with 44, it might be, well, no, I think all of them are. Starting with 35 through 53, they're all in the ME's office, right? Those are all as part of documenting. Okay,
Yes, sir. Yes, sir.
thank you. Other than, Mr. McDermott, is your argument that, I think I heard one argument, which was that they are the photographs 35 through 53 are cumulative of photographs in the field and don't need to be shown again. Do you also assert that photographs between 35 and 53 are cumulative of one another, that there are multiple photographs?
In some cases, yes, Your Honor.
Okay. So the same request I made earlier, Mr. Fawcett, and I trust that you endeavored to already do that. But to the extent that the photographs taken in the medical examiner's office are necessary and relevant to demonstrate how the examiner examined the remains to arrive at their opinions, I think those are relevant and admissible despite their graphic nature. Thank you. But I would also want to avoid needless repetition of the same photograph.
In further, further effort to comply with the court's instruction, I will propose eliminating 39, 38, and 35. I believe that would eliminate the 2 photographs of the head. That would just be the head and the field. 39 would be I believe, looks like a knee portion to me. There would still be that photograph of that in the field, and it might benefit the jury that it's not as close up as that. And then 35, which is the neck. So I
No,
think
35 is the head.
35 is the head. Okay, so then I would take out 38.
Okay.
And I think 36 and 37 are representative of, I think, both sides of that neck column, so I would propose that.
Okay. Mr. McDermott?
Well, I'm fine with those deletions. I would also ask that 53 be deleted because it's repetitious of 56. And although I think there's a question to be asked fairly, on 53, you can see the kind of connective tissue at the far right side. If that was part of the examiner's testimony, that's how, part of how the leg was removed, or something of that nature, it would be more relevant. But I would say choose between one of those 2 photos. I would prefer 56 because it's less gruesome.
53 and 56.
They're the same bones from different angles.
Mr. Fawcett?
I'm fine with that, Judge.
Okay, so which one?
53.
I'm sorry, you'll remove 53 or you'll remove 56?
I'll take out 53.
Okay. So what I have so far is the state has agreed to remove 35, which is a second photograph of the head, even though we have a close-up of the recovered head in the field, which is remaining in evidence.
I do appreciate how they are
But the
working
state
together
has,
to be sure
agreed
to
to withdraw 38,
present
39,
present the jury with
53.
what they all think is the important part of the case without being overly gruesome. I appreciate that. I think they've done a really good job. I think this judge does a very good job of keeping her her colleagues, the prosecutor and the defense, in check. I think this is all really well done.
Mr. McDermott, other than your objection to the nature of the evidence and its graphic nature, et cetera, do you still specifically have other objections you wish to make a record of?
Unless I wrote them down and you have it,
Yes, sir.
then no.
Okay. Well, to try and be as clear as I can, to make the record as clear as we can, Mr. McDermott moved to exclude 35, and 35 has been voluntarily withdrawn by the state. Mr. McDermott did not move to remove 38. He did move to exclude 39 through 42. The state has agreed to remove 39, but to keep 40, 41, and 42. So to the extent necessary, I'm going to deny Mr. McDermott's motion to exclude photographs number 40, 41, and 42. Mr. McDermott moved to exclude 44, 46, and 47. I'm denying that motion. As to Mr. McDermott moved to exclude photograph 50, the state has agreed to remove that one. Mr. McDermott moved to exclude 51. That motion is denied. Mr. McDermott moved to exclude 53. 53 has been voluntarily withdrawn by the state. Mr. McDermott moved to exclude 54, 57, and 59 that are various angles of saw marks. Other photographs in the packet that the state has offered, including 55, 58, and 59, are various angles of those same saw marks. And the state has agreed to withdraw 55, 58, and 59. And based on that showing, the defendant's motion to exclude 54 and 57 are denied, and the defense's motion to exclude 59 is granted because the state agreed to withdraw it. Anything else, Mr. McDermott, about the photos?
No, Your Honor.
Okay. Mr. Fossett, anything that we need to take up before we get started with the evidence?
No, Judge, if I could just have a few minutes to take out the exhibit.
I was just going to say, yeah, and I'll run through them again. You have, my notes indicate agreed to withdraw 35, 50, 53, 58, 59.
Yes.
Is that going to give me enough time for a comforting break?
Yes, although I do have all my jurors, so as soon as y'all can get back and be ready, we'll be ready.
All right, so they're going off the record. Jury will be coming back in shortly. I actually had to run downstairs real quick, pick up the doorbell rang. So I missed the end of that, but it does seem like they became of one accord when it comes to which pieces of evidence will be admitted, shown to the jury, with the defense's issue being that they were overly gory. Okay. But, all right, we'll be back when they are back.
Question?
Yeah, regarding the grooming order again,
Yes, sir.
we're being told by the jail that they have lost their clippers. And I don't know if there's anything you can do about that, other than maybe scold them mightily. But it would be very helpful. I gotta do what I can.
Thank you.
Thank you.
Hey, deputies, can you do me a favor? I entered a grooming order 2 days ago for Mr. Wolfenbarger. He's still not been allowed or enabled to have a haircut. If I could ask the two of y'all to please prioritize that and communicate it to whomever you need to so that that can happen today in advance of tomorrow, I'd appreciate it. Thank you. Anything else, Mr. McDermott?
I have a problem with
Okay.
local jails, man.
We have everyone back, and I'm told that we have all of our jurors. Are we ready to get started yet? I don't want to rush Mr. Facetas for a moment.
Yes, Your Honor, I just will let the court know the first witness does require a wheelchair,
Okay?
so he may take a little bit of time to, should I go ahead and tell
Is
you?
that person going to be able to get on the witness stand, or are they going to, we're just going to?
Probably on the side or the front or however you would do it.
Okay, are we concerned at all about volume?
I am. I'm concerned about volume.
Until he, maybe.
Okay.
Is there a portable mic that we can get a hold of?
Technically, these things, although they are affixed very well, are in fact removable if it came right down to it. I'm not worried about the jury hearing that person. I'm worried about the court reporter and the other people in the courtroom.
And
Yes, sir.
Gavin Fish is
Like
true
the whole
crime.
base.
And he's gonna be right here. Yeah.
Okay.
Best way to do it.
That is the best way to do it. Okay. State's ready. Mr. McDermott, is defense ready?
Yes, ma'am.
Okay, we're ready for the jurors.
Hope we're able to hear this witness. By the way, the whole grooming order thing and him not getting a haircut, all that stuff, they can't find their clippers, is all bullcrap, in my opinion. It's all bullcrap. County jails are the absolute worst when it comes to treating their people in their custody right. Yeah, I just see it time and time and time again, all the time. And here's the thing. While we're waiting for the jurors to be seated, we want a fair trial for the purpose of getting the guilty convicted and the innocent set free. We want fair trials, and stuff like this. It can
Please be
mess around.
seated.
It can mess around with the process.
State may call its first witness.
Thank you, Your Honor. State calls George McEachern.
George McKeetrick
Okay.
is who we're listening to. I do not know why the defendant is in a wheelchair. I still have no idea.
You'll turn around, sir, so that you'll be facing sort of this general direction towards the deputy, where the deputy's standing, if you can. Turn a little bit more so you're facing the deputy, so you won't have your back to the jury. That's good, sir. Now, are you able to raise your right hand, sir? Okay. If you would, thank you.
You swallow a fire. This is the moment you're about to give court today. Shall you the truth, the whole truth, and nothing but the truth? Yeah. You may lower your right hand, state and spell your name for the record, please.
George W. McEachern. That is spelled W-M-C after E-A-C-H-E-R-N.
Okay. Mr. McEachern, this is the judge talking. I'm behind you, so don't worry about that. If you could, just because you don't have a microphone, if you could just try to speak up when you're answering questions to make sure everyone in the courtroom can hear you. Okay, sir? Thank you. Go ahead, Mr. Wilson.
Thank you, Your Honor. And you live in Atlanta, sir? How long have you lived there?
48 years.
48
And
years he's
did you
lived in
ever live
Atlanta.
in the area of Avon Avenue, in the general area? Do you still live there? How long have you lived at your present address? Yeah, okay, thank you. What did you do for a living?
I want these things for my website.
I apologize. We can't hear him.
Hold on a second, sir.
Get him a mic.
Should I try to get the microphone?
I'd say give it a try.
That's a good idea. Get him a mic. There are tons of people on Zoom. I mean, it's not just us. It's not just for us, though. We appreciate it if they're well mic'd. There are people attending the trial on Zoom. So I imagine that's pretty important that they are able to hear the testimony. All he said so far is that he lived in the area of Avon Avenue for the last 48 years. He's lived in Atlanta for the last 48 years. That's at least what I could hear anyway. Yeah.
Taped together.
Would you like to try?
Yes, please.
Hopefully this is going to work.
That's,
It's coming though. I can see it moving.
all right.
Whenever the sound drops out there, that it's dropping off from the feed. That's not me changing the sound.
You see if you can get closer to the microphone that we have there for you, sir. Yes, sir. Mr. Yes, for now. Hang on. I apologize. Why don't you have him come to the podium, and against all directions, we're going to have him move. We're going to move the microphone. Thank you. Just bend it down towards me. I'm going to have him come right here. Yes, ma'am. And then, Mr. McEachern, if you could turn a little bit more and face the jury, please, sir. And now.
That's looking like it's getting nice and close to him. Hopefully that's going to work.
Yes, Joy
There we go.
W. McEachern.
Much
Last-
better, sir. Thank
Last
you.
name spelled capital MC, capital EACHERN.
Thank you, sir. Go ahead, Mr. Wilson.
Thank you, Your Honor. And do you remember in April, at the end of April of 1999, an unusual thing happening an unusual thing you found on Avon Avenue?
Yes, I went for a walk that morning to the bank, and on my way back, I came up Avon Avenue, and as
And what did you see?
I saw a head, a human head that was laying in the street. So I walked up to it, and I looked down at it, and I saw it was a head.
How did you know it was a head?
Well, through my training in mortuary science and
His training in mortuary science.
directing, I recognize human heads.
Human head?
Yeah.
What did you do?
I took a stick and I moved it out of the street to the curb of the road,
Why did you do that?
so it would be intact I didn't want anybody, another vehicle to come and, crack it up. So I moved it to the corner.
Could you repeat the last part where you said, I think you said crack it?
I did not want a vehicle to come and run over their head and deform it. Because I saw it belonged to somebody.
What did you use to move it?
I broke off a stick. And I took the stick and I tried to push it over to the curb.
Did you see anything else unusual on Avon Avenue on that day? I mean, was there any other things that you can recall?
Well, I didn't know there was some birds, some birds flying up in the air, looked like buzzards.
Okay.
And I recognized that might have been the reason why they were there. But I told the officer after I called them that I thought there could be something else out there in the woods because the buzzards were still there.
Okay. Yeah. Now, after you found the skull, what did you do next?
Hey,
I went
hang on,
home,
I'm going to
I
pause
got
this
my
just for a
daughter.
second. I don't want to do this throughout his whole testimony, but look, this happened 25 years ago. Imagine he would have been in much better shape, much better witness if he could have been a witness 25 years ago.
Because she was in criminal justice,
Okay.
and I wanted her to see the head.
Okay.
Yeah.
And did your daughter come with you?
She did.
And what did you do next?
Called the police.
Okay.
Called 911.
And after you called 911, how long did it take? Do you remember how long it took the police to get there?
That recognition survey right now. It wasn't long. But right now I cannot recall how long it was.
Okay.
But
You
they
didn't
did.
think it was long?
No, I didn't think it was long. But
How
they,
many police? Do you remember how many police showed up?
no.
Was it just one or more than one?
He'd be a much better witness 25 years ago.
I do know they were one. There could have been more than one, okay?
Because you talked to the one?
Yeah, I talked to the one, yeah.
Okay. And did you go anywhere after you initially told the police out on the scene? Did you go anywhere with the police?
I do know I had to go downtown.
Okay.
But I can't recall whether it was the same day or not, or whether it was a few days later. But I do know I went down to the Atlanta Police Department.
Okay.
I think it was down there, Georgia State College, Ponce Leon, somewhere down in there.
You went to the headquarters?
I went to the headquarters, I think it was.
And
You-
I
you-
assume you told them what you saw?
I told them the same thing I'm telling you now. Yeah.
And do you remember if you gave any statement or had to sign a statement or anything, just saying what you did?
I'm pretty sure I had to, sir. I'm pretty sure I had to.
I'm going to show you a piece of paper. Do
Okay.
you recognize that? Mm-hmm. Is that your signature?
That's my signature.
Yeah. Could you read it real quickly? Is that the statement that you gave?
Sir, I'm going to be honest with you in the courts. When I gave this report, I was walking, I was younger. I could see better.
Well, can you read the
And,
hours?
and right now, I cannot make this out.
Okay.
Let's say today around. I don't have my glasses with me.
Are they around?
I don't know. But baby, have my glasses like that?
I really like this guy. Yeah, 25 years ago, he would have been a much better witness. I keep saying that. Couple things.
Mr. Wilson, just to clarify, are you asking the witness to read it to himself, or are you asking him to read it out loud?
Read it to himself to see
Thank
if it
you.
refreshes him.
Yeah, Mac McCollum helped on this.
Look at me. Thank you.
Do you need some assistance, sir? Apparently not.
What you want me to do with this?
Does that help you?
Yes, you may read it to myself.
Yeah, read it to yourself real quick.
Okay.
I wouldn't be able to do it without my glasses. I like this witness.
The true, all but a few, maybe a few sentences.
Do you know?
I was driving. I wasn't driving. I was walking at the time.
I apologize. I think you
Say that
said,
again.
yeah.
I wasn't driving. I was walking at the time.
Okay. Did you?
Yeah.
Does that help refresh your recollection
Yeah,
at all?
sure, it does.
Do you remember finding anything else other than a human head?
I don't.
Okay.
I
Now,
don't.
how long have you lived? You've lived in Atlanta your whole life.
No,
Where else did you live?
no.
How long have you lived in Atlanta?
Ever since 1960.
Ever since 1960?
Yes.
And Avon Avenue, is that located in Fulton County?
It is.
May I just have one moment, Your Honor?
Sure. Thank you. Mr. McDermott, questions for this witness?
Just a couple, Your Honor.
Sure.
Good afternoon.
Hello, sir. How are you?
Just a couple questions.
Okay.
You said you informed the officer on the scene that there were buzzards certainly overhead. Is that correct?
I did.
And did they go over and check anything else, to your knowledge?
I don't know. They told me they were going to, but I think what happened a few days later, somebody came by my house and told me that they had found another body part, and they were going to try to match the head with that body part. However, as far as I can remember, sir, it wasn't in Atlanta they had found that body part. I think he told me to find somewhere near Griffin, Macon, or somewhere down in the area. Somebody told me they had found a body part, and they were trying to mess it up. And that's the last I heard of that.
Is this a walk that you took every day or frequently?
No, this was a walk that I decided I wanted to walk that morning to the bank.
Did you ever normally travel up and down Avon?
It's in the early 2000s.
Sometimes.
Did you ever notice any dogs?
Brother, there are homes in that area. I'm sure there are dogs in that area
Or did you
also.
ever see any when you were traveling up and down Avon Avenue?
Yeah, you know,
Do you remember? All right, thank you.
no.
That's all the question I have.
Thank you. Mr. Wilson?
No redirect, Your Honor.
Okay. Mr. McEachern, you are excused as a witness. Thank you very much, sir.
Thank you, ma'am.
So it just seems to me like they wanted to establish that this is how her head was found, how Melissa's head was found. Not much more than that. He doesn't seem to have the best memory. Again, it happened 25 years ago. He's now an old man. He's got some disabilities that he's dealing with. Yeah, I think that's about all they're going to get out of him.
Dale Kelly.
Okay. And if you could move that mic back,
Yes, ma'am.
and then we're all going to try not to touch it again. Thank you.
I actually like the microphone system that they have here. They're not all dynamic mics. They tend to pick up everything that we want to hear. These are cardioid mics of some sort, I'm sure.
Before you have a seat, if you'll turn and face the deputy and raise your right hand.
Do you swear or affirm the testimony you're about to give for the state shall be true, the whole truth, and nothing but the truth?
Yes, sir.
You may go right hand and be seated. Say, spell your name for the court, please.
Careful. That chair is on wheels and there's a ledge next to you, so
Yeah,
make
sure.
sure and stay closer to me than the edge, okay? Thank you, sir.
Dale, Kelly, Kelley.
Dale Kelly.
And what do you do for a living, sir?
Retired,
What did you do before you were retired?
law enforcement for 42 years.
And let's go through your law enforcement career. Where did you first become a law enforcement officer?
In 1979 in the city of Atlanta.
And when you were hired, did you have to get it? Well, tell us about your hiring in the city of Atlanta.
July 2nd, 1979 was the first day I started the Atlanta Police Academy. We were there for 12 weeks, and then after you got out of that, you rode with a senior officer for 12 more weeks in field training. I became a patrol officer. I was assigned to Zone 1, which is northwest Atlanta at that time. 83, I was promoted to detective. I did Vice for about 6 months. That was during Eldon Bell. He thought all new detectives needed to go undercover and then come out and get in a regular division. I went to sex crimes. I worked in sex crimes, total of 13 years, but whenever they had a sexually related homicide, I would get pulled over and help the homicide detectives work a sexually related homicide. And then in 1996, I was permanently assigned to homicide.
Were you post-certified?
Yes.
Are you still post-certified?
No, I do not keep my mandated.
Okay. And when did you leave the city of Atlanta?
I retired in 2000 from the city of Atlanta, went to the Douglas County Sheriff's Office, worked there, started in the jail, worked patrol. I went to CID. From CID, I made sergeant. I was a night shift sergeant for a patrol shift. And then I went to the fugitive unit, the warrant unit in plain clothes. And then from there, I made lieutenant and was over the transport and civil division.
Now, did you receive any specialized training in investigations?
Yes, I mean, I've been as far as California on missing persons, violent crime network training. I've been to Valencia College 3 or 4 times on advanced sex crimes, advanced homicide, crimes and like that.
Now, during 1999 and in around April, could you describe what you were in the homicide division at that time?
Yes, sir.
Tell the jury what happens when you get how does that work? Or how do you get assigned cases or what?
Well, okay. You were on a rotation system where you were up on call, and if anybody called for a homicide unit, you would answer and go wherever they asked you to go. You didn't go by yourself. Half the time, the whole unit would go. You were just the lead, and they would do other jobs needed at the scene.
And when you say lead, what does that mean to you?
You were up on call, and the case was going to get assigned to you.
And when you're lead, what kind of things do you focus on?
Well, you get to the scene, you try to focus on directing the identification people to do fingerprints some places, sometimes you don't, take pictures and stuff like that. You may ask like the officer, the first responding officer, if there's a witness at the scene or something, you get the officer to take himself and the witness to the homicide office where they could give statements.
And let me draw your attention specifically to April 29th, 1999. I assume you were on call that day.
Yes.
And did you receive a call regarding a unexplained, well, I mean, what kind of call did you receive that day?
The way it works is Zone 3 Unit 2304, which meant he was a day shift unit working 304's beat, came over detective radio and called for a homicide unit. Each zone, and Atlanta still has 6 zones, they all have their own radio frequency. Detective division had their own frequency, and they would just switch their radio over to the detective frequency and call for a homicide unit.
So it was your turn?
It was my turn.
And where were you told you needed to report to?
He told me to come to the intersection of Avon and Hartford Way Southwest in Atlanta.
And what did you do?
I got in the car with the lieutenant, and investigator Tina Miller also rode with the lieutenant, Tony Biello, and we rode to that location.
And why did Investigator Miller accompany you?
Again, on a homicide, you need as many people as you can out there. We didn't know what we had other than a unit calling for us, and we could always use help.
Okay, so she went along?
Yeah.
Okay. And when you got to that location, what did you observe?
When I rolled up, there was a decomposing head in the road standing upright. There's an old black plastic bag to the side, and there's an old mangy, like a stray dog with matted hair and all, kind of nasty, running around out there.
Okay. And do you recall where that skull was located?
It was on the side of the roadway it was actually on the Avon side, because we used the address of 858 Avon Avenue.
So the dog must have found the black
Now,
bag,
when
dragged
you're
it out.
investigating a crime scene, is it important to document information?
It is, yes.
And you document the reports and also pictures?
Well, you call for I didn't take the pictures. I called for our ID section to come take the pictures, and it's up to them to document their pictures.
Okay. No, what I mean is that it's important to take pictures of
Yeah,
crime scenes,
yeah,
right?
yeah.
Okay. May I approach a witness, Your Honor?
Yes.
I'm going to show you what's been marked as State's Exhibit 3 through State's Exhibit 20. Could you please look at those and tell the jury what those are?
They're pictures of the general area of where it was located, and ID had saw certain objects, they put the little plackets up at, and it's,
Could you look through those, please?
yeah.
Thank you.
Okay.
Are those true and accurate pictures of what you observed that day?
Yes.
Your Honor, at this time, I'd ask to admit States 3 through Exhibit 20, which are photos of the scene.
No objection.
Okay, Mr. Samuel, thank you. Exhibits 3 through 20 are admitted.
And I would ask to publish some of the pictures to the jury as we go through the testimony as far as
Okay.
a warning.
Thank you. That's what I was waiting for you to ask.
Yes.
So, ladies and gentlemen, as we discussed during the process of jury selection, I told you that I would warn you when we were going to show you photographs that are maybe graphic in nature. So I'm giving you a heads up that some of these photographs may be graphic in nature. Thank you. State may proceed.
Thank you, Your Honor. Okay. Show you what's been marked as, or what's been admitted as State's Exhibit number 3. Could you kind of describe that picture in detail for the jury, as best you can?
It's an overall shot.
Glad they're publishing those to us.
Area where the head was found.
Can you speak up a little bit?
Sir, I'm sorry.
If you
It's
could
a-
pull that microphone towards you, I think that'll be easier as well.
It's an overall shot of the area where the head was found, and the head's actually in the photo to the left here. or
Oh,
my
yeah, I
left,
see it.
Looking at it, and you see where the patrol cars had blocked off the street.
But I do see some yellow things with numbers
Yeah.
on them. What are those?
Plackets, ID team uses, they see stuff.
Right there.
or Maybe an investigator will point out. to put a
You see
placket, take
what I'm pointing
pictures,
out
so it
here?
can Be described later in their reports.
Okay.
Pretty cool that they publish those to us. I guess they have to publish them to the witnesses on Zoom, and it looks like Court TV is logged in through Zoom.
What other items were there other than the placards?
Well, there
I'm sorry. What other items were there than the skull that you described earlier?
There was a black plastic bag. It appeared to have decomposition in it, hair, and fluids.
And was that significant to you as a investigator?
Yeah, later, when the cadaver dogs were called out, other body parts were found in the black plastic bag, and also had fluid in it that ended up being bleach.
Okay.
Oh, that is nefarious.
So when you saw those pieces of evidence, I assume that was kind of the first thing that was kind of done.
So the
at
head's
scene?
placed in a black
Yes,
bag with bleach.
I cannot legally touch any body out there. It's all up to the medical examiner. I can look at it, I can have photographs taken of it, I can note it, but that's entirely up to the medical examiner's office to do any collection of body or body parts.
Were they contacted? Did you guys contact them, or?
Yeah, they came out to see him.
Okay, do you recall who came out to the scene?
Mary Beth Happel and Dr. John Parker.
Okay.
Mary Beth is an investigator for Fulton County Medical Examiner, and Dr. Parker was a medical examiner.
Okay. And what did you do? What did you do next?
Well, we started, hard to run an investigation if you don't know who your victim is, and this one's even doubly hard. We didn't know what sex the person was.
Why is that?
The decomposition of the facial and the torso, we never found it. So you couldn't ever determine a sex at that time. The feeling is the torso contains the guts of the thing, and it would smell more, and the animals out there would have eaten it quicker.
Okay. Do you recall what the conditions were like that morning?
Yeah, I noted it.
Would you have noted that in your report?
As I rode over with Lieutenant Biello and Investigator Miller, the weather conditions to be overcast with a intermittent mist, and the temperature was in the low 60s with a brisk breeze.
So after you got there and after the medical examiner got there, what did you do next?
Nothing could do much other than make a report.
Did you talk to any? Do you remember speaking to any witnesses?
Well, there's a gentleman who had found the head. Gentleman's just in a wheelchair, but he wasn't in a wheelchair at that time. I talked with him. I sent him to the homicide office to give a statement, and the officer on the scene took him there for a statement.
Do you recall any other actions that you did out there at the scene that day?
That day, no.
So at this point, all you had was a skull and some plastic bags, pretty much.
Yeah.
Did anything? Did you find anything else?
I got that, JoJo.
And
Thank
on
you.
a different day.
On a different day, yes. That's,
Were you called back out to the scene?
yes, went back out there with the medical examiner's office. They had gotten in some cadaver dogs from Cobb County. These people who owned the dogs were not associated with law enforcement in any way. They were just citizens who trained their dogs to become cadaver dogs and would help agencies as they needed it. And they came back out there, and that's when we started finding hands, feet, and other body parts. They were also in a black plastic bag like I described earlier, and they were always double wrapped. There was always 2 bags per body part. That kind of makes sense with me there.
And I don't know. I don't know if you said. Do you recall what date you went out to the scene?
The first, it was April 29th, and then this was June 3rd,
So that's approximately, what, a
a
month,
month and a half later
month and a half later?
to get it set up.
Now, is the president, you mentioned bleach earlier, I'm sorry, you mentioned bleach earlier.
Yes.
Is that significant to collection of DNA?
Not for the collection, for the destroying of DNA.
Your Honor, you've not been given an expert notice with regard to this witness.
Your response?
Well, Your Honor, I think that's
a good
that's
objection.
not- I think it's something that a police officer can, based on police officers' evidence collection, could probably, could testify to as within their knowledge.
Okay. If you want to lay that foundation, I likely will allow it. Overruled for now, Mr. Samuel. Go ahead.
Okay.
She's going to make him go through the process
Did
of
you learn
how'd you learn about DNA?
About bleach?
Well, DNA, it's not the same as today. This was in the beginning stages of DNA. And a lot of things would interfere with DNA. When I worked sex crimes, if there was anal sodomy, the feces would ruin the DNA and you couldn't test it. Learned that bleach and
Where did you
gas,
learn
training
that?
classes I took
Okay.
that would hurt DNA. Nowadays, they probably can do it even if there's bleach on it.
Well, what did you learn about bleach at that time through training?
That it would interfere with the ability to do DNA evidence with what they had to test with at that time.
Your Honor, at this time, I believe I've laid the foundation based
Mr.
on his
Samuel?
training.
And we still then never got notice of him being an expert. So if he's giving expert testimony about DNA, you're entitled to be given notice of that.
Okay. I understand your objection, but it's going to be overruled, and to the limited extent you've been asked the question, I'm going to let him answer it. Go ahead.
Hey guys, if you do
I think
have
he's already answered it.
if you have expertise in finding things and researching, please reach out to me like Autumn is saying.
What did you do? What did you after you went out and on the in June? What did you do next on this case?
There's nothing I could do until, again, you can't start much of an investigation until you know who the person, what sex the person is, who the person is. You have nowhere to start. So Investigator Miller, who worked adult missing persons, is assigned to homicide. She would attempt to identify the body. Medical examiner's office was trying to identify. They could hook up with other medical examiner's offices and do the thing, and hook up and see if they had any information. I retired in 2000.
Okay, well, and that was, you never got an answer by the time you retired?
No.
Okay. May I just have a moment, Your Honor?
Sure.
Nothing further, Your Honor.
Thank you. Mr. Samuel?
Detective Kelly, my name is. It won't happen a second time.
That's okay.
It won't happen a third time. Detective Kelly, I don't believe we've met before, even though we've been around a long time together. So a couple questions. First of all, you said something about a dog on the scene. Do you have any reason to believe that that dog had ever moved the skull at all?
I believe so. I believe the dog drug it out of the woods. And
Or you're just speculating about that?
there was a video, the VHS recording.
Can you stick with the microphone?
There was a VHS recording at one time that showed the dog dragging the bag out of the woods. Now, I don't know where it's at
Dragging the
now.
bag with the skull out of the woods?
Yes.
There was no detectives out there until after the skull was already there.
VHS recording. That's a security camera. It's so old. It was
Where is the evidence of that?
I'm sorry.
Has anybody ever had evidence of that? Is that in any police report anywhere?
I don't know.
Are you just kind of making it up today?
No,
I've read every report you've ever written, every report every other detective has
you haven't
written.
written all, written. There are reports missing. I don't know why, but there are some reports missing. in
Have
this
you told the
file.
DAs there are reports missing?
Yeah. But I mean.
Which DA did you tell that there are reports missing?
Gentleman here just questioned me
Uh-huh.
that I had more reports in this file and they're not.
And
nowhere to be found.
where's the VHS?
I don't know.
Did you tell them there was a VHS recording that's missing? You told
Yes,
Mr. Wilson that? When did you tell him that?
the other day when he called me.
You told him the other day?
Sir?
You told him the other day?
Yes.
Is there a
Called
reason
me
you?
last week. Or, yeah,
And what else did the recording show?
just that.
Did it show how the skull got there at all?
Just what I described.
A dog pulling it out of the woods. Where from what part of the woods? Well, it's not in your report, you know that.
I'm telling you, I have reports missing out of this file. This is not my whole file.
Take your time.
It's from the wooded area where we returned with the cadaver dogs. It was coming from that area where the other bodily parts were found in the woods.
What did the dog look like?
Like it was a stray dog. The hair was all matted and nasty looking.
Was there any dog hair found on the skull?
I don't know.
Was there any testing done of the skull to show that a dog had moved it?
I don't know how you do that because it was remember the black plastic bag? It was ripped open. The dog was toting the bag and it fell out.
And you saw a video of that.
Yes,
What did you do with the video?
it was put in evidence.
You know, I think we need to take a break and talk to the district attorney's office for a moment here.
Okay. Ladies and gentlemen, I'm going to ask you to step out for just a few minutes. It's 2:21. I'll try and get you back in here as quick as we can. Thank you all.
All rise for the jury.
So it looks like we've got a little snafu going on here. Very interesting. Let's see what you guys are saying while we're waiting for the volume to come back on. Thank you, Jen. I will take a look.
Moment, please. Yes, sir.
Okay.
Thank you. Don't wander far, okay?
Just see if we're.
His reports that are lost, evidence that they knew.
I'm going to go back.
This has now left the room.
All right.
Mr. Samuel, that witness has now left the room.
Well, I have a couple questions. I'd like to know, first of all, whether Mr. Wilson will either corroborate or dispute that he's been given information about video camera evidence that's lost, his reports that are lost, evidence that they knew that the dog had dragged the skull out of the woods into the road. There's no police report about it, and now it turns out his actual statements are missing, all of which apparently he told the DA's office, none of which even comes close to ever having been revealed to us, ever.
Mr. Wilson?
If I could respond to this, Judge, because I was talking directly with this witness on this issue. If the court
Okay.
will allow it.
Sure.
All right. I do have information about the comment about.
I have to go again, guys. Sorry.
This witness. We were not able to locate the video. I didn't know there was a video of that description until I had that discussion with this witness. the detectives, Shepard, suspected that there was a dog or dogs in the area that may have carried the head out from the wooded area to the street where it was located. That's been his theory since the beginning of the case.
Right, but inferring that from the presence of a dog that Mr. McEachern testified to is different than we recovered some sort of surveillance video that showed it, but then we lost it.
Sure, and that was never intended to be introduced into evidence by the state. That's why it wasn't elicited during direct. We had a video cassette. We had several small mini cassettes. At the beginning, before the case was indicted, those were submitted to a company in DeKalb, and they were transferred over to a thumb drive, which was submitted in discovery. And they're labeled as such, converted VHS. It's in discovery. But that's the only VHS cassette that I've received from APD Annex. The multiple times we've gone, I don't have a VHS cassette.
Okay, hang on. The physical nature of the physical medium in which the state might have it or not have it, I think is less important at this point than does the state have some sort of video that would line up with what this witness is saying he observed? Like some digital video recording of that image?
I don't.
Okay. And so the videos that you're saying you were aware of that were reduced by a private company to a flash drive or something and were produced in discovery, what are those?
Those are all statements, witness interviews,
Okay.
which have been turned over.
Okay.
That's the only VHS cassette that I've seen in this case. A lot of mini cassettes that have also been converted. I only had one VHS cassette.
Okay. I appreciate that. Again, I think it would be easy to identify it if it was a VHS, in your possession. But I think more importantly is, does anybody know that such a video ever existed, whether on VHS or anything else?
I didn't have a documentation of that in the Detective Calhoun's report. I didn't have a documentation of that in Detective Shepard's report. And I didn't see any reports that Detective Kelly had written that elicited that information. And of course, all the reports that I have from Detective Kelly appeared to be complete.
Okay.
I had no reason to believe they weren't. But, so like I said, I never intended that this information would come in because I didn't have a way to authenticate it. Other than that detective testimony, I knew that wouldn't have been permissible to elicit it. He had just him testifying to it.
Okay.
I never intended for that to come out.
Mr. Samuel? I think the answer to your first question is, well, actually, to be honest, now that I'm trying to put it in words, I'm not actually sure I'm clear on what the answer is. And that was why I was trying to make the distinction between the VHS and the video.
Yeah. Let me explain to you how I see the problem. We have been working on this case, Mr. McDermott in particular, 24 hours a day, 7 days a week for Lord knows how many months at this point. He's been in communication with the DA's office. There's been a lot of open file, and yet apparently they're not telling us about evidence that's lost, about videos that are lost, about their second witness on the stand who's saying he was the chief investigator in the case and some percentage of his reports are lost. Now, either the DA's office says they were oblivious to all of that and they learned that the same time I did, or they've known it all along and didn't tell anybody. Meaning you, us, the destruction of evidence, the loss of evidence that may be important, the loss of police reports from witnesses. From a chief investigator from the original crime scene, he says his reports are missing, and nobody's telling us that the witness is just going to, blurt that out on cross-examination for the first time. And, this business about bleach is not in his report. There's references to bleach in the report, but according to the crime lab that we interviewed, it had nothing to do with bleach in the bags. It was bleach that was done by the crime lab to clean the bones.
And that's a matter for cross-examination.
Well, but he's saying, now he's saying, I've got bleach in the bags. There's no report anywhere that says that.
And again, that's a matter for cross-examination unless there is some report that has not been provided to you. But I'm going to ask you to put a pin in that for a moment and revisit this with Mr. Fawcett or Mr. Wilson. I'm still not sure I understand the answer to the question, which is, before Detective Kelly took the stand, Did the state have an understanding that he believed there were other reports that he had made that were missing, number one? And number two, that he believed there was a video showing what he's described about a dog with a bag in its mouth pulling it into the street, which was containing some body part or other? Two questions. What are the answers to those two questions?
Yes, I was provided that information last week when I spoke with him.
Okay. And what efforts did you take to determine if such evidence did in fact ever exist and or was lost or in your possession?
Well, I went back through the file to see if there were additional reports by Detective Kelly. So the reports from Detective Kelly, I sent him portions from the file that we turned over. I went through our additional discovery. I saw additional reports that were turned over. Similar reports to the first one. They were 1 or 2 pages, so not what he's discussing. But I wasn't able to locate any additional reports by Detective Kelly, and that's been through the several times that I've gone through the discovery.
Okay. Okay, so you were aware that Detective Kelly believed that there were other reports that were not in your file?
That was last week, yes.
Okay, but I understand you only became aware of it last week, but you did become aware of it at some point.
That's correct.
And what about the second question, which is, were you aware that Detective Kelly believed there was some sort of surveillance video that had been recorded at the time that reflected what he's described?
Yeah, that's the same conversation.
Okay.
Week, yes.
And did you disclose, and I'm not implying here that you were obligated to, we can have that conversation in a moment. My question though is, did you disclose to the defense at any time that Detective Kelly believed that there were reports that were missing or that he believed there was a surveillance video that was missing?
I did not have that discussion now.
Okay. Mr. Samuel, I think I've gotten the answer to those questions. Go ahead.
Well, I have the same. The first question says, why would you not disclose that to the defense? That we're going to put a witness on the stand who, in essence, is going to ambush you on a cross-examination because you think, defense counsel, you have all of his reports. We know you don't. So if you cross-examine him, you're going to find out that he's going to say, oh, that's absolutely true. I have got additional reports. They just were never given to you.
What obligation does he have to disclose to you?
The prosecution has an obligation to report missing evidence, right? A VHS camera. He can't just say, it's missing, so I'm just not going to bother asking questions about it on direct examination and let the defense attorneys walk into a trap where the witness can say, oh yeah, what other videotapes are missing? Do they have a videotape of the crime being committed they haven't told us about that was lost? I mean, this is somewhat not the most important thing in the case, whether the skull was dragged out of the woods or wherever it came from. I'm just very concerned if by witness number 2, we're discovering that the prosecution knows there's missing evidence, missing surveillance cameras, missing police reports. They know that that's true, and they're not even telling us about it. It's bad enough that they're missing, which is understandable after 20 years to some extent. It's not understandable why they wouldn't tell us.
So the question then, Mr. Samuel, is what relief would you have the court give you in light of the fact that it wasn't disclosed to you? Is that not something that you can remedy on cross-examination and with this witness and argument?
I have no idea what he's going to say because I have no idea what this witness is going to say that hasn't been disclosed to us. The whole point of discovery in a criminal case is you give us your witness statements. Now it turns out he knows a lot more about this case.
I understand.
Did they know? The
But that wasn't my
prosecution
question.
knows.
My question was, what remedy would you have me fashion to address this issue if I agree with you that this is a problem? Is it go talk to the detective and figure out what he's going to say before you have to cross-examine him in front of the jury?
I was actually going to suggest that you tell the jury, disregard the witness's statement as of now. At some point later in the trial, if they want to bring him back after disclosing to us the statements he gave to them that's missing from what they gave to us, if there's something more than the VHS, something more about the bleach, something more about whatever I haven't, stumbled upon yet, When a witness talks to them, that's a witness statement also that hasn't been turned over to us. Not just the witness statement that's lost, but what they told him, what he told them last week is a witness statement that hasn't been disclosed to us. You can't interview a witness, find out relatively important information and say, I'm not going to put it in writing, so the defense attorney's never going to learn about it.
Understand? Thank you, Mr.
I would ask that the witness you tell the jury not to pay attention to what the witness has testified to, and we'll bring them back later in the trial if appropriate,
Thank you, Mr. Samuel.
after the prosecution does what it's supposed to do.
Mr. Fawcett?
Yes, I think I could understand, still wouldn't agree with it, but I could certainly understand Mr. Samuel's position if we were going to take his, I guess where he's going with it, there's some nefarious intent, some bad faith on the part of the prosecution to do that. I will say I am not immune to oversight for overlooking items, but hindsight I would have. But I will say this: I had no intention on not turning that information over. I didn't think it was of any consequence. I thought at the minimum it would benefit the state, but finding that information out on a Friday or a Thursday before the trial, I did think that was somewhat of an ambush. And again, also at the same time, I would say this: I believe the defense has contacted just about every witness that we've had on the witness list since the beginning of this trial. Detective Kelly's name has been in the discovery. Since the discovery was turned over, there are 3 total detectives, and I know for a fact they've subpoenaed detectives from the Patton investigation, and so if they had called the Detective Kelly, he would have been willing to speak with them. But to infer that there's some nefarious intent in the process of just simply preparing for trial and interviewing the witnesses, I think it's a bit much. At a minimum, at a maximum, I can understand the court we're going to instruct the jury to disregard the last statement, but to instruct the jury to disregard the entirety of his visual observations and testimony about that when he arrived at the scene, I don't believe there's any reason for the court to decide in that manner.
Okay. I have a couple of questions. Let me try that again. Has the defense spoken or attempted to speak to Detective Kelly prior to today?
We have not, Your Honor, and I'm looking for the state's witness list that was sent to us currently because I don't think we were ever given any contact information for him, and he's retired, so usually not kept by the police department.
That the state provided does list Detective Kelly as Detective Dale Kelly, APD.
Okay.
So, that doesn't actually answer my question. Is your answer that you haven't attempted to contact Detective Kelly because you weren't provided contact information and you weren't able to otherwise locate him because he's retired?
That wouldn't be 100% honest, no.
Okay.
If I could say, I'm not sure the blame should be on us.
I'm not implying that I'm blaming you. I'm asking what information did the defense have that they could have exercised in terms, right? I'm just trying to understand the scope of this. It'd be one thing, for example, if y'all had tried to contact the detective and he'd refused to speak with you. That's what I'm trying to figure out, so.
I understand that's your question. I'm not quite sure the consequence of it. If we trust the prosecution, that when they give us the reports, we have the reports. If we have to go and consult all 18 of the witnesses on the list now, all 30 of the witnesses last week, and all 150 in the original list, and say what is missing from your police reports, this case wouldn't have been ready to be tried this year.
Okay.
But
Thank you, Mr. Samuel. So I still think that the answer the way to resolve this in the most expeditious manner is for y'all to go into that conference room with Detective Kelly and find out what he's going to say is missing from his report. Because whether or not Mr. Fawcett should have told you is a different matter than whether or not this detective can testify truthfully about what he believes happened in response to questions. Mr. Fawcett is correct that they didn't solicit that testimony. And to the extent that you believe you've not been given complete information, Mr. Fawcett has made representations about what additional information he believes there is. And you can ask Mr. Detective Kelly those questions while we wait and bring the jury back in. I don't think, I mean, it's 2:40. I feel like an initial conversation with that detective to find out what else he's going to say and how many reports he thinks are missing. That's a fair conversation for y'all to have before I decide what to do about his testimony, or to simply have him retake the stand and let's continue his cross-examination with you having the benefit of the additional information that he believes is missing. Mr. Fawcett, is that, or Mr. Wilson? I think he was technically your witness, but.
Yes. And so the court's going to go in, would the court allow a recess for them to speak with the witness?
Yes, that's exactly what I'm proposing.
I think that's the way to do it.
Okay. So, Mr. Wilson, if you will go and gather Detective Kelly, and y'all can either discuss it in the lobby or you can go into that conference room in the atrium there, or you can go in that conference room and discuss with him what items he believes are missing or that sort of thing. Thank you. We are in recess until 3 o'clock, or if y'all come back sooner than that or later, tell me.
Hey guys, just going to take a quick moment, quick opportunity, since we're kind of chatting in the live stream. As you know, this is during my day job. I'm doing my normal daily activity while we're covering this case. Tonight at 7:30, which is our normal time for live streaming, we're going to go ahead and do a primer on this case to kind of understand where we are in the case. This case seems to be coming out of nowhere for most of us, though it is. I mean, obviously, they've been working hard on it there in Georgia. I just happened to stumble upon it on Court TV's website. But while I've got your attention, couple things. We're going to do that. We'll do the primer tonight. Tomorrow night at 7:30 p.m., which is August 15th, I'm going to be joined by Joseph Scott Morgan, and we're going to be talking about the 16 photos that came out of the right to know request, the whatever it was, whatever they call it in Idaho, public records request. Those photos that came out of the prosecution of Brian Koberger, as he is a medico-legal death investigator, he'll have some insights that I just did not have. So I will do my best, Robin, to not say blood splatter. That the L from the blood comes out in the splatter for something. So blood spatter. I will do my best, though I'm sure that he will extend me lots of grace on that stuff. So that's going to be tomorrow at 7:30 p.m. Eastern. Tonight, we will talk about this case, the Melissa Wolfenbarger case. I don't like calling cases by the murderer. I'd much rather call the cases by the victim. Anyway, just wanted to let you know that, and then I'm going to go back to. Oh, JoJo is saying that. Let's see. What is JoJo saying? Let me come over here. JoJo is saying that she is going to try to get us some more docs. I already from her got the indictment that we can take a look at. So JoJo, if you get those, I'd appreciate you sending those my way so that we can talk about it. TYO Toys says, do I think Jim McIntyre is involved in this case? I really don't. But you know what? Maybe Mr. McIntyre will make an appearance. I don't know. But yeah, and Mooney says she will transfer little notes I have, or she has, to a better format. Wish I had a court notebook. Hey, my daughter, my amazing daughter, is working on that. We are going to create that reporter's notebook. If you guys don't know this, I work as a reporter in my day job, and I just go to Walmart and I get notebooks, and then which one is this one? Yeah, so this is my trial notebook from the trial of Brandon Wells, the murderer of Bradley Walters. Anyway, we're gonna create a notebook so that we can use those. You guys can kind of, I don't know, should be something that's fun. I don't see anything. Yeah, we all need our own FBI personal assistant. That is funny. So anyway, that's that. I just wanted to break in and talk to you about that before I have to go back to the stuff that I'm doing. All right. So with that, I will be back when and if they come back to us here on Court TV.
The individuals at the medical examiner's office determined that the skull belonged to a white male. I didn't agree with that, but they were the experts, And so it was listed on the system as a white male. And what we did was we put the individual, we put the skull for sure, and we had to do them separately because at this point we didn't know they were the same person. I put the individual on.
We have audio. We have video. Now we don't have audio. I feel like we're getting close. Come on, Court TV, you can do it. You can do it. Looks like we may have another witness here. Maybe not. I wish I were a lip reader. Well, that was anticlimactic. Come on, man. That was a tease. That's what that was. Our judge is a little bit of a tease in her courtroom. Hopefully they'll have us back soon. That might be the end of the day. That might be the end. Yep. Court TV is saying we'll be providing a replay on YouTube with chat due to the error. Thank you for being patient. Man, this kind of thing just happens every once in a while, right? Just happens. And I don't know if they're going to call it though. That they've still got a live stream there. So we'll stick with them until the live stream ends. I don't know if that was end of court for the day or if that was just, hey, we're going to take a quick break. I don't know. But I'll be back if Court TV is back. Okay, that is the end. that is the end. And kind of an anticlimactic way to end, kind of a bummer, but the good news is we're going to be back together tonight at 7:30 p.m. Eastern to talk about the case. So thankful to JoJo for finding the indictment, and I will do a little bit of research once my workday ends, and we'll be ready to go at 7:30 tonight. So join me then, and then we'll be back tomorrow live streaming the case. All right? With that, I bid you adieu. See you on the next one. Watching this video. If you liked what you saw, please consider subscribing. And if you have any questions or comments, please leave them below.